Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
The clerk of court will please call the matter at hand.
Called for continuation of oral arguments are the consolidated cases in RH Law, starting with GR number 204819 and 13 others. Appearing as counsel for petitioners, James Imbong et al. And John Walter Huwat et al. Are the following: Attorney James M. Imbong and Attorney Joe Aurea M. Imbong. Appearing as counsel for petitioners, Alliance for the Family Foundation of the Philippines Incorporated et al. Is Attorney Maria Concepcion S. Noche. Appearing as counsel for petitioners, Task Force for Family and Life Visayas Incorporated et al. Is Attorney Makilito B. Mahinay. Appearing as counsels for petitioners, Reynaldo J. Chavez MD et al. Is Attorney Jean L. Uy, and for petitioners, spouses Francisco S. Tatad and Maria Feni S. Tatad et al., the Honorable Francisco S. Tatad, and Attorney Honorable Francisco S. Tatad. Appearing as counsel for petitioners, Couples for Christ Foundation et al. Is Attorney Luisito V. Liban. Appearing as counsel for public respondents are the following: Honorable Edsel Silagman. For the Office of the Solicitor General, Solicitor General Francis H. Delesa. Assistant Solicitor General Hermes L. Ocampo, Assistant Solicitor General Derek R. Pertoliano, Senior State Solicitor Florin Hilbay, Associate Solicitor Emerson Bañez, Associate Solicitor Maria Cristina Navarro, Associate Solicitor Isa Katrina San Jose Valdez, Associate Solicitor Ivan Mark Ladores, Associate Solicitor Maximo Paulino Season III, Associate Solicitor Leia Teresa Labadan, Attorney Elvira Josel Castro, Assistant Solicitor Elvira Josel Castro. For intervenors, we have Honorable Pilar Juliana S. Cayetano, Attorney Elizabeth Aguiling Pangalangan, Attorney Herminio L. Harry Roque. For intervenors, the Filipino Catholic Voices for Reproductive Health, Interfaith Partnership for the Promotion of Responsible Parenthood, Incorporated, and Melissa Baya Mones Saria Mapandi. The following are appearing: Attorney Clara Rita Padilla and Attorney Ray Paulo Santiago. To argue this afternoon are the following: Congressman Edsel Lagman for 13 minutes on the right to life with emphasis on legislative intent. Senator Pia Cayetano for 13 minutes on right to life with emphasis on maternal health and right to health, and Senior State Solicitor Florin T. Hilbay for 15 minutes on freedom of speech, religion, academic freedom, and local government.
The rest will please take their seats except for the Honorable Edsel Lagman. You may begin, Congressman.
Honorable Chief Justice, Honorable Associate Justices, may I proceed? After 13 long years of extensive, comprehensive, and heated debates inside and outside of the Congress, the Reproductive Health Law, or RA 10354, has been enacted with absolute fealty to the Constitution and the Commonweal. It took almost 1.5 decades for the Congress to pass the RH bill because all of the objections and reservations of the oppositors were answered and addressed. The concerns of the allies of the Catholic hierarchy in the Congress were heard and some even accommodated. Constitutional issues were freely ventilated and exhaustively debated. The critics in the Congress participated in the long drawn-out process and even introduced amendments, many of which were accepted and incorporated in the bill. At the end of the day, the duly elected people's representatives in the political departments, the legislative and executive, have categorically spoken for the RH law. The sovereign people, majority of whom are Catholics, in survey after survey, have decidedly spoken for the enactment of the RH law, including its salient features. The international community has likewise clearly spoken in jubilant celebration of the final passage of the RH law. We earnestly beseech the Honorable Supreme Court to rule for and speak on the constitutionality of the RH law. We seek a pluralistic unanimity on a truly outstanding legislation which seeks to protect the lives and well-being of families, women, and infants by affording voluntary beneficiaries universal access to reproductive health and family planning information, services, and supplies. Educate adolescents on proper sexual values. Alleviate poverty by meaningfully addressing the empirically validated nexus between population and poverty, and accelerate the achievement of sustainable human development for the Filipino people. The right to life provision, which mandates that the state shall equally protect the life of the mother and the life of the unborn from conception, is intended solely to prohibit the Congress and the Supreme Court from legalizing abortion. Verily, what was sought to be outlawed was abortion, not contraception or contraceptives, which were vastly and readily available in 1986, contemporaneous with the deliberations and adoption of the subject provision. Indeed, contraceptives have not been declared illegal. The use of contraceptives has not been criminalized. This is a recognition that conception is not abortion. This is a recognition that contraception is not abortion. While contraception prevents pregnancy, abortion terminates pregnancy. To ban contraceptives now is a veritable retrogression. The expert opinion of the UNDP, UNFPA, and the WHO underscores that, and I quote, "It is universally recognized that contraception is the most effective intervention to prevent unintended pregnancy, abortion, child and maternal mortality and morbidity," unquote. Specifically, it has been validated that regular and correct use of contraceptives reduces abortion rates by as much as 85%. The following provisions in the RH law make the Act's anti-abortion policy indisputable. First, it recognizes that abortion is illegal and punishable by law. Second, abortion is not included in the menu of family planning methods, which is limited to those which are medically safe, non-abortifacient, effective, and legal. Third, one of the elements of RH is the prescription of abortion. Fourth, RH rights do not include abortion and access to abortifacients. Fifth, the repealing clause provides that prevailing laws against abortion are not repealed modified, or amended. Finally, Section 4A defines abortifacients as referring to any drug or device that induces abortion or the destruction of a fetus inside the mother's womb, or the prevention of the fertilized ovum to reach and be implanted in the mother's womb upon determination of the FDA, a formulation introduced principally by the oppositors of the RH bill. Consequently, the following are unmistakable. 1. An embryo or fetus must pulsate in the mother's womb in order that an abortion can be committed to the use of abortifacient. This adheres to the standard definition of abortion, which is the expulsion of an embryo or fetus before it is viable. 2. The prevention of the fertilized ovum from reaching and being implanted in the mother's womb makes a drug or device an abortifacient as determined by the FDA. This addresses the claim, albeit not medically and empirically validated, on the third mechanism of action of contraceptives, which purportedly makes the uterine wall hostile to the fertilized ovum's implantation. 3. The Act's prescription of the third mechanism of action is intended to assure the implantation of the fertilized ovum in the mother's womb for its viability. This makes the RH law genuinely protective of the life of the unborn. This innovative definition expands the limited action of abortifacients from the traditional destruction or expulsion of the fetus to encompass preventing the fertilized ovum from implanting, a prior phase in the reproductive process. This formulation was accepted as a concession to the critics of the RH bill, who wanted to ban the yet unproven third mechanism of action of contraceptives. Consequently, the Act protects the implantation of the fertilized ovum while in transit to the uterus, even before it becomes a fetus. Verily, the petitioners have no reason to complain. 4. The first two validated mechanism of action of contraceptives, which are the inhibition of ovulation and the prevention of the sperm from fertilizing the egg, are obviously not included in the definition of abortifacients because prior to fertilization, there is no unborn which is entitled to protection. Hence, the avoidance of fertilization is not abortion, and contraceptives with these pre-fertilization actions are not abortifacients. The foregoing unequivocal provisions uphold the constitutional ban on abortion and the mandate to protect the life of the unborn. With the inordinate concentration on protecting the life of the unborn, almost forgotten is the first part of the mandate, which calls for the equal protection of the life of the mother. The RH law is not oblivious to this twin mandate. The promotion of RH and family planning equally protects the life of the unborn and the life of the mother, the living person in the equation. Planning a woman's pregnancy is protecting and saving her life from avoidable maternal morbidity and mortality. The use of contraceptives minimizes the incidence of high-risk pregnancies, which result to maternal death. High-risk pregnancies are associated with the phrase, too young, too old, too many, and too soon. Pregnancies among teenagers and older women, as well as those of women who already have many children and those who have unremitting pregnancies, make such women prime candidates for maternal death. The NSO recently reported that mortality in teenage pregnancies has increased, even as 14 Filipino mothers die daily due to complications related to pregnancy and childbirth. This is due to lack of access to RH services and products. Multiparity or having many children is gravely associated with maternal mortality because with each additional pregnancy, a woman's life lifetime risk of dying from pregnancy or childbirth-related causes progressively increases. Family planning saves lives. This is the simple and incontestable truth. The WHO, the UNDP, and the UNFPA confirm that correct and consistent use of contraceptives will prevent 1/3 of all maternal deaths. Moreover, birth spacing through proper contraception assures the birth of healthier infants. The WHO concludes that if a woman have information and access to contraceptives and are taught If women have information and access to contraceptives and are taught to use them properly, the fall in maternal mortality is likely to be even greater than the fall in the pregnancy rate. Since contraceptives saves lives of women and infants, far from being poison, they are medicines that avert maternal and infant morbidity and mortality. Maternal deaths and infant mortality have become silent epidemics of alarming proportions. Although pregnancy is not a disease, it can kill. It is fraught with mortal risk. Thus, contraceptives are included in the WHO's model list of essential medicines. Similarly, the FDA registers and approves contraceptives for sale and use as drugs and medicines. While contraceptives have side effects, they are not singularly life-threatening. Even aspirin has side effects. The actual benefits of contraceptives far outweigh their potential risk. The chances of dying within a year of riding a car is 1 in 5,900. It is 1 in 200 from using pills, 1 in 1 million in having a vasectomy, 1 in 10 million from using IUD, and absolutely 0 for condom use. But the risk of dying from a pregnancy is 1 in 10,000. All methods of contraception, whether natural and traditional or artificial and modern, have one common objective: the prevention of unplanned pregnancy. The differences lie in their differing efficacy and their contrasting harmony with human instincts and desires. Father Ruben Tanseco, SJ, wrote that, and I quote, "Natural family planning has not worked effectively in our country. For so many poor, uneducated couples, learning NFP as the only means of family planning is too difficult, cumbersome, and needs much discipline and spirituality. Many are not able to make it. The poor are already deprived of so many things, and to deprive them of love-making when they spontaneously feel like doing so is to make their lives even more miserable," according to a Jesuit clergy. The Proclamation of Tehran on Human Rights in 1968, of which the Philippines is a signatory, declares, and I quote, "The protection of the family and of the child remains a concern of the international community. Parents have a basic right to determine freely and responsibly the number and spacing of their children," unquote. Millennium Development Goal number 5, as amended, aims at achieving universal access to reproductive health by 2015. Again, the Philippines has committed to achieve the Millennium Development Goals. Freedom of informed choice is central to the Reproductive Health Bill. While the state is mandated to provide universal access to legitimate contraception, the ultimate choice belongs to women and couples, the voluntary beneficiaries. A couple or a woman may opt not to choose any method at all. This option is both a civil and religious right, which the RH law respects and protects. Neither the church nor the state can compel citizens or the faithful to adopt a particular family planning method. The free and responsible choice belongs to an acceptor. The UNICEF asserts that, and I quote, family planning can bring more benefits to more people at less cost than any other single technology now available to the human race. This would be true even if there were no such thing as a population problem, if one just considers the prevention of maternal and infant deaths from unwanted conceptions. Pertinently, the 2012 State of the World Population Report declares that having children by choice and not by chance leads to healthier families and communities. Considering that the RH law is against abortion, abhors coercion, and respects freedom of informed choice, this act is not only presumed constitutional, it is indubitably constitutional. Thank you, Your Honors. Your Honors,
Yes.
I have an impaired niece, and pending my operation, I cannot stand for long periods.
It's all right. Congressman Lacman, you may take the seat, please. But the justices might have questions for you.
Yes.
Justice Mendoza?
I defer to Justice Abad.
Justice Abad?
Counsel, I'd like to be clarified on the exact meaning of abortion, because my reading of the law is that there is abortion when there's a prevention of the fertilized ovum to reach and be implanted in the mother's womb. This is what the law says.
That is not, Your Honor, a definition of abortion. It is a definition of abortifacient.
Yes, well,
Because an abortion means that there is a fetus which is expelled from the uterus before it becomes viable.
well, but as far as this
in
law is
this
concerned,
particular case, Your Honor, prevention of implantation, there is yet no fetus in the mother's womb.
well, as far as the law is concerned, what is the correct definition of abortion?
The law did not define abortion, Your Honor.
But what's your understanding of it under this law?
Well, under this law, Your Honor, abortion is the expulsion of the embryo or fetus from the mother's womb before it becomes viable.
Okay. So now, there's a question on. You said that the FDA will determine whether a product or supply is an abortee patient. But from the discussion during the last hearing, some contraceptives or hormonal contraceptives or IUDs sometimes function also as abortee patient, in the sense that now, even with the try to prevent ovulation takes place, tries to prevent fertilization, it takes place. When it takes place, the contraceptive works a third function, which is to abort, to prevent the fertilized egg from implanting effectively on the endometrium. So, how will the FDA, that's not in the law, no? How will the FDA apply this principle? Will it assume only or pass as not abortive patient those that have merely secondary function, or only on the basis of their primary functions?
The secondary function or mechanism of contraceptives, which is reportedly preventing the implantation of the fertilized ovum in the mother's womb is not yet medically validated. But as a concession to the critics of the RH bill, we accepted their definition of abortifacients to include drugs and devices which will prevent the implantation of the fertilized ovum in the uterus.
Well, that will, from my reading, that will practically exclude all hormonal hormonal contraceptives and IUDs.
No, Your Honor, because principally the hormonal contraceptives would prevent fertilization either by inhibiting ovulation or preventing the sperm from fertilizing the egg.
But what you're saying now is not in the law, no? That's not the law, that's your thinking. But the law does not say that the FDA should consider as abortifacients contraceptives that have secondary function of causing abortion.
That is in the law, Your Honor. I was the one who amended the proposition of the critics of the bill.
What section of the law? Because I
the section 4A, which says upon section 4A, which says upon determination of the FDA.
Okay. So now you said that one of the reasons for this law is the consideration that of the maternal mortality in the Philippines as well. Well, from Bill Gates and Bill and Melinda Gates Foundation study made of the Philippines and other countries, it says the maternal mortality ratio in the Philippines is declining. 443 per 100,000 in 1980, 174 per 100,000 in 1990, 103 per 100,000 in 2000, and 84 cases per 100,000 in 2008. That's what the study says. So just imagine that with this number, there are about, from my estimate, there are about 23 million childbearing ages women in the Philippines. So if you just say half of them will take these contraceptives because of this law, that will be about 11 million or 12 million. So we will put intrauterine devices in 12 million women to avoid these 84 deaths out of 100,000. Put them at the risk of, I'm reading from WHO, irregular bleeding during menstruation, headaches, increased risk of pelvic inflammatory disease, perforation occurs in the uterus, unexpected pregnancy during IUD application, pain in the pelvic region from WHO, cramping and pain especially by copper IUD, impulsive expulsion, breast tenderness, vomiting, spots on skin, etc. We put 23 million of our people, of our women to face one or some or all of this for maternal mortality that can be met actually by sufficient hospital facilities. These deaths really could have been prevented if blood were available in the clinics, there are competent doctors on hand. They would have been prevented. But your cure is contraceptives for 23 million childbearing women in the Philippines.
Well, Your Honor, in the first place, that data from Gates Foundation is not consistent with our own government data. The NSO, which says that 14 women die daily because of complications from pregnancy and childbirth. And I think we should believe our own statistics. Number two, no one is being compelled, Your Honor, to use contraceptives, to use IUDs, or even to use condoms. It is freedom of informed choice. It is the option of a woman or a couple whether to use or not contraceptives. And then, despite the findings of a sub-office of the WHO of this risk, which are not actually life-threatening, and it is similar to other drugs and medicine, the WHO is still included contraceptives in the essential list of medicine. And the WHO is the main health authority of the United Nations, to which the Philippines is a member.
The government wants to encourage and promote the use of artificial contraceptives at such cost and, as I said, at such possibility of risk of certain dangers. Yet from my reading from the WHO reports, there are actually other options, like, for example, although the Catholic Church will not approve this, but male condom is 98% good with correct and consistent use. It says there. And 85% as commonly used. So what we need is to teach them correct and consistent use. There's another one, withdrawal. 96% with correct and consistent use. 73% as commonly used. Fertility awareness, I think this is the natural method. 95 to 97% with correct and consistent use. So education is important. 75% as commonly used. And here's the other one. Abstinence. 100%. Because if married couples love each other and willing to make the sacrifices and learn also the art of abstinence and love, then that will also work, isn't it? Don't you think so?
Yes, Your Honor. All of this will work, but which will work effectively?
Yes.
Your Honor, let me just say that the RH law does not promote artificial methods of family planning. It promotes all methods, both the natural, the artificial, the traditional, and the natural modern methods of contraception and family planning.
Well, okay.
We are giving the people the option to choose. If they want to choose abstinence, then they can do so. Nobody is being compelled to choose otherwise.
Yes, that's good. Now, I remember mentioning at the last hearing the right of every person to substantive due process of law. This means that every law must have a proper governmental purpose, that the means chosen is reasonably related to such government purpose, and it does not go so far beyond the necessity of the case as to be arbitrary. A simple classroom example is a law that requires all restaurant personnel to wash their hands before handling food. Such law would not violate the requirement of substantive due process because, first, protecting public health is a proper governmental purpose. Second, the washing of hands by restaurant personnel before handling food is reasonably related to that purpose. And third, such washing of hands before handling food does not go so far beyond the necessity of the case as to be arbitrary. On the other hand, and this is the problem, if the law requires all restaurant personnel to wash their hands and further to immerse their hands in boiling water before handling food, such law would violate the requirement of substantive due process. Because although immersing the hands in boiling water would probably help clean the hands, such requirement goes so far beyond the necessity of the case as to be arbitrary or oppressive. All right. So here in this law, The apparent purpose of the law, as stated in its title, is to promote responsible parenthood and reproductive health, correct?
Yes, Your Honor.
This, you claim, is a proper governmental purpose, right?
Yes, Your Honor.
If the means chosen for attaining that purpose will enable parents to freely and responsibly decide the number and spacing of their children, then such means would be reasonable related to the purpose of the law, correct?
Yes, Your Honor.
Which is the promotion of responsible parenthood and reproductive health, correct?
Yes, Your Honor.
Now, those means are in the nature of washing of hands in our example because they are related to the purpose. Now, I do not believe that anyone seriously objects to the provisions of this law requiring more public maternity hospital and clinics and adequate facilities and medical supplies or a greater number of trained health workers. Those would be reasonably related to the purpose of the law, correct? These more facilities will help promote the purpose of the law.
Yes, Your Honor.
Now,
That would be another solution to the problem, but that is a more expensive solution to the problem because, as we have said, family planning and reproductive health are cost-effective.
no, but the law from my reading from your law is asking for better facilities for government.
Yes, Your Honor. That is
Well,
that is
nobody
consistent.
objects, I think.
That is in addition to the promotion of reproductive health and family planning.
Okay. To me, the real issue, the real contention here is the RH law's adoption of certain means that would promote and ensure the massive distribution and use of hormonal contraceptives and intrauterine devices to people from age 10 and above. I want to know if these means are reasonable, the wash your hands kind, or are arbitrary, the boil your hands kind. So, several provisions of the law speaks of safe and non-abortive patient family planning products and supplies that parents and individuals can use. Is that correct? There's something those in the law.
Yes, Your Honor. What is being promoted are contraceptives, which are...
There would be nothing essentially wrong ensuring use of only safe and non-abortive patient products. Is that right?
There's
nothing wrong with that. Does the law itself say what specific family planning products and supplies it considers safe and non-abortive patient?
Well, Your Honor, under Section 9 of the RH law, it is a wrong impression to conclude that Congress declared certain contraceptives like hormonal pills, IUDs, and the like as safe, legal, and non-abortive patient. The Congress did not do that, Your Honor. What the Congress said is that the Philippine National Drug Formulary should include drugs and devices which are considered as contraceptives, like hormonal pills, IUDs, and the like, provided that they are safe, medically safe, legal, and non-abortive patient. In other words, Congress gave a standard which the FDA must follow in its registering and approving what are contraceptives which are not abortive patient.
Well, maybe that's your understanding, but may I just go over the law. No? It says, Section 9, the National Drug Formulary shall include hormonal contraceptives, intrauterine devices, injectables, and other safe, legal, non-abortive patient, and effective family planning products and supplies. The law uses the word shall include, right?
Yes, Your Honor.
Counsel, yeah.
Shall include.
Meaning that by force of law, all hormonal contraceptives and intrauterine devices, their products and supplies, are safe and non-abortifacient, and therefore are to be included in the National Drug Formulary. Is that correct?
We regret that we cannot agree with the conclusion of Your Honor, because what the law says, and I quote, the National Drug Formulary shall include hormonal contraceptives, intrauterine devices, injectables, and other safe, legal, non-abortifacient, and effective family planning products and supplies. The provision on safe, legal, non-abortifacient, effective family planning products and supply is not a declaration by Congress that the previous enumeration are safe, legal, and non-abortifacient.
Well,
it only says that the FDA should follow this standard in determining whether these hormonal contraceptives,
Well, let me go over
intrauterine
it.
devices,
The law says,
injectables,
yes,
are to be part of the National Drug Formulary.
no, the law says, from my reading, the law says that this artificial contraceptive shall be included, so it's a command, no? Shall be included in the National Formulary, Drugs Formulary. And under the law, that means that that is the same as the essential drugs list of the country. That's the same. And if a product or a supply is in the essential drugs list, it means that it is available to the public. It is to be purchased by the government for the distribution free to those who may be in need of it. There's nothing there that says, and the only role that was given to the FDA there in the same section is that the FDA shall merely issue a certification that those who buy this or something should not use them as abortifacient. And let me see, do you agree with this? The Solicitor General said in his comment that Section 9 is a legislative finding of fact based on scientific evidence in the hands of Congress that these artificial contraceptives are safe and non-abortifacient products and supplies. Page 31 of the OSG comment. Actually, my reading is the same as the OSG. This is our reading, so you have another interpretation.
Your Honor, it is true that medical researches and findings were submitted to Congress when we deliberated on this particular section. But, Your Honor, neither Your Honor or the Solicitor General was in the midst or in the thick of the deliberations of this particular section. I was there, Your Honor, and this is the intention of Congress.
Well, the problem is that even your colleagues who voted on it in the Senate and in the House of Representatives would, of course, be reading the bill as final, the wordings of it. It will not be reading your mind. That's just as we are. Huh?
Yeah.
We are not bound by your impression.
That's why, Your Honor.
Even the Solicitor General who represents the government and Congress, he represents government. The Congress says that this finding is a binding legislative declaration.
Your Honor.
That hormonal contraceptives and IUDs are safe and non-abortifacient. And nobody, you said even the Supreme Court should defer to it. That's what OSG says.
Your Honor, just on the question on when life begins, where Congress doesn't have the competence. Congress doesn't have the competence to decide and to declare that certain contraceptives, like hormonal contraceptives, intrauterine devices, injectables, are safe, legal, and non-abortive.
I'm glad you accept that. I'm glad that
This is not
you accept
this
that.
is not the jurisdiction of Congress. It is the jurisdiction of the of another of an administrative agency which has the competence to do that.
But those who will enforce the law, the government itself, represented by the Solicitor General, understands it as this, as legislature telling us that these drugs are safe and non-abortifacient. And I recall, I was reading a pocket book that my dad said, I think before, the invention of penicillin. And there appears there an article that says that the best cure for syphilis was cyanide during that time. But later on, penicillin was discovered. But if our Congress declared that as the cure to syphilis, we will be in trouble. So now, we have here a legislative declaration that hormonal contraceptives and uterine devices are safe and not abortifacient. If the Supreme Court upholds this law, that will be binding on all government agencies, even on the Supreme Court in the future decisions, on all prosecutors and policemen. And they will act accordingly. But as we know, these matter, scientific propositions, are changing all the time. They are changing all the time. We need to repeal this law if it turns out that it is false.
Precisely, Your Honor, because the frontier of science is unlimited. And medical science would advance on a daily basis. That's why Congress did not declare that these contraceptives are legal and non-abortive.
Therefore, we should annul this Section 9 because it says differently from what you're saying.
No, Your Honor, it does not say differently. It's it is your conclusion which is different from the intention of the members of Congress, Your Honor.
I'll say. Well, anyway, so there's a problem there. Section 23 makes it a crime for any healthcare service provider, public or private, to intentionally provide correct information regarding a full range of legal, medically safe, non-abortifacient family planning methods. Yung mga doktor at nurses, bawal magbigay ng maling salita tungkol sa contraceptives. Ganun ba, counsel? They cannot give incorrect information, and that will be punished by law.
It says knowingly, Your Honor.
It says incorrect information.
Yeah, knowingly.
Yes.
Knowingly,
now,
giving incorrect information.
If this law is upheld by the court, the assumption is that the doctors have read Section 9 that says that hormonal contraceptives and IUDs are safe and non-abortifacient, then they are bound by that knowledge. You agree?
They are bound by the declaration.
They are bound by what the law says.
No, they are bound by the declaration of the Food and Drug Administration on what are
not by the law, but by the...
Because
how about this provision of the law? They can ignore that?
The law delegated that authority to the appropriate government agency which has the competence to determine.
So, if the doctor tells his patient that the oral pills the patient wants is not safe or free of any danger, contrary to what the law says, that it is safe, the doctor will be giving him information that the law regards as incorrect. Yes?
Well, Your Honor, it would be on a case-to-case basis. It all depends on the circumstances during which that particular information was given by the doctor.
So there are a lot of things to look for.
Yes, Your Honor, because it's all evidential.
But a law that punishes cannot be vague. A law that punishes cannot leave things to the police officer to determine what will constitute a crime.
No,
the law must clearly say the acts that could constitute a crime. That's basic in criminal law.
The law is not vague, Your Honor. It defines what is prohibited. But whether a person who is accused of violating the law is culpable or not is a matter of evidence.
No, let me ask you, does the law define the meaning of incorrect information? It does not.
Well, there is no need to define that, Your Honor, because that has ordinary meaning.
Well, but as you said, scientific propositions, medical propositions are changing. You know? So police officers have to read developments in medicine all the time to determine whether there's a violation of this. We will be placing our selves at the mercy of law enforcers who will determine whether at a proper time this is correct or incorrect.
In the final analysis, it would not be the police enforcer who is going to determine the culpability or innocence of a person accused under this law. It would be the courts.
Well, initially the police officers, the law enforcers are the one to determine for filing the case in court. Anyway, suppose the doctor discourages his patient from using oral pills and copper IUD, not because of any religious belief, but simply because, as a doctor, he taught them too unsafe, contrary to what the law says. Can the doctor go to jail?
Well, Your Honor, again, it's a matter of evidence, you know. It all depends on how this advice or counsel was given by the doctor and what was the condition of the patient. It is possible that the patient has
No, supposing the
health
patient, there's
problems.
nothing wrong with the patient. So the doctor must have to advise him that they should get this. This is safe for him, for her, contraceptive, artificial contraceptives.
If the doctor knowingly made that wrong information to a patient who is entitled to use contraceptives, then the doctor should suffer the consequences of his culpable and incorrect advice.
Why even entitled? A patient will say, I'm entitled to. Patients usually go for consultation because they don't really know anything. So he will trust in the competence and wisdom of the doctor. And the doctor says, well, I don't believe that these are safe. The law says they are safe, but I don't believe that. So I'll not advise you. So the doctor will go to jail.
Well, if the evidence would sustain his guilt, then so be it.
Yeah, it's okay. So, but if the government wants to promote oral pills and copper IUDs that it believes are safe and non-abortive patient, should it not compete in the marketplace of scientific ideas and not proclaim by law that this is the only correct idea, that these contraceptives are safe and non-abortive patient?
There is no such proclamation by Congress, Your Honor.
Now, under Section 2 of the RH law, the state guarantees the right of individuals to information they need to make decisions for themselves. Is that correct?
Yes, Your Honor.
Also, Section 3, guiding principles for the implementation of the law is to the same tenor, correct?
Yes, Your Honor.
Is the question of whether or not artificial contraceptives are safe and non-abortive patient a matter of public concern?
Definitely, Your Honor.
Well, Section 7 of Article 3 of the Constitution provides that the right of the people to information on matters of public concern shall be recognized. You get that?
That's section...
Under Section 7 of the Constitution, no?
Yes,
the
sir.
right of the people to information on matters of public concern shall be recognized. Now, but since Section 9, in effect, tags as incorrect any view and will punish views that the government has adopted as correct, it seems to me that this violates the right of the people to information on matters of public concern if other ideas are barred. Even erroneous ideas are barred. You see, incorrect information will be punished. So this law will only protect correct information approved by the government and not allow for any other incorrect information.
Well, the law provides for the dissemination of correct information.
Yeah, well, no, that's your best answer now. Does not
Why
the
should
right
the law
of a person
encourage the dissemination, why should the law have a provision that incorrect information should be circulated? You know,
incorrect? Correct. What is correct? Incorrect will be decided by the government.
Yes, Your Honor, and eventually by the
truth.
court.
Well, we have a problem, you know. If we rely on the government for what is correct and incorrect,
Well,
I think people should be able to think for themselves also what is correct and incorrect. Don't you agree?
The government has adopted a particular public policy, and the policy is the promotion of responsible parenthood and reproductive health, and also the promotion of all methods of family planning, which are medically safe, legal, effective, and non-abortifacient.
Okay, well, that's your best answer. Now, does not the right of a person to make a choice in relation to reproductive health imply a right to seek advice from one he trusts?
Yes, Your Honor.
Suppose a woman wanting to space her pregnancy, especially seeks the advice from a physician whom she trusts, and the latter, a Catholic, expresses his belief that taking oral pills or using copper iodine is evil. Would this physician go to jail for giving such advice?
Well, that could form part of the law's respect for religious freedom, and so the woman can get a second opinion from another
my
doctor.
question is, does this doctor who tells this incorrect information go to jail?
Well, if that could come under his religious belief, then religious
He go to him as a doctor. It happens to be a Catholic.
Yes, Your Honor. But if that is an advice coming from a doctor, is a Catholic, and that is his religious belief, then most probably the law would respect religious conviction and religious belief. Because
Well, I thought we wanted to stop religious, what they call that, dictatorship or things like that. That you think that is existing.
Your Honor, I think all of these questions would be in an arena where evidence should be introduced, because it's very hard to make a hard and fast assessment and resolution of these questions.
But I gave you the facts.
Yes, the facts.
I gave you the evidence.
The facts are that so treated that I think there is need for.
No, but on those facts, I know that there may be other variables.
I said that
on those facts.
Well, if that would be part of his religious belief, and the law respects religious conviction and belief, then he may not be culpable for any violation. But there is also the principle that religious freedom is a grant of religious liberty, not civil immunity. So all of this will have to come into play.
Well, I'm glad that's your interpretation, but we are bound by the language of the law. Okay. Now, religious conscience is part of the consideration for a pre-choice in family planning. Is that correct?
Yes, Your Honor.
And that one can seek advice from a healthcare provider regarding the latter's religious belief. Even if he's a public doctor, in a public health center, in a government hospital, he's a Catholic doctor, he can give advice different from your official line. No.
Yes, Your Honor, if that is part of his religious conviction and belief, which is being...
No, but this is also public duty. He said he's a doctor paid by the government.
That's why, Your Honor, I am saying that we cannot just state certain facts and that's it. You have to decide on those limited facts.
But I gave you the facts. He's a government doctor.
Cases which reach the court cannot be resolved with that kind of constricted facts, Your Honor, because there are interplay of the medium of evidence as well as the doctrines. Like, for example, as I've said, religious freedom is a grant of religious liberty, but not civil immunity.
Unless
an invocation of religious freedom should not stalemate the state in not pursuing and implementing a public policy.
Well, that's true. That may be true. Huh? Actually, you cannot, exercise of religion cannot, what do you call that, be an inconvenience also or cause injury to other people. No, I don't think that's the position taken by the petitioners. At any rate, Section 4Q4 provides for guidance and counseling for adolescents. That is from 10 years old and upwards, yung mga nasa grade 4 at pataas. They are to be guided and counseled on the use of all methods of birth control, including, of course, oral pills and copper IUDs. Is that correct?
Well, are we referring, Your Honor, to
Section 4Q4?
Q4, section...
Says there, guidance and counseling for adolescents on all methods of family planning.
Section 4...
So my 10-year-old granddaughter will go to school and he will be taught this, that these are safe.
This should be read in connection with the section on sexuality education, Your Honor.
Well, I don't know, but it says here merely, he shall be given counseling and guidance. That's another part. No? Education, that's different. But this one is guidance and counseling. Okay. These kids from 10 years upwards are therefore to receive instruction in school that it is safe to use oral pills and copper IUDs, correct?
It should be age appropriate, Your Honor. Because
they will be taught this because it says there all methods of...
Yes, but I think we should be able to read the law in its entirety.
Well, what it says, that's what I should read it. What it says to me.
Well,
I'm not behind. I'm not into other. Kumbaga sa contract,
can I
parole evidence rule? I cannot proceed other things.
Can I get again the particular section, Your Honor? Or what is the particular section you are referring to, Your Honor?
I beg your pardon?
What is the particular section you are referring to?
Section 4Q4. Section 4, letter Q, number 4.
Section 4.
Section 4, letter Q, number 4. I think this is definitions. Huh?
Definition of terms.
Yes.
Huh?
Section 4.
Section 4 is definition of terms, Your Honor.
Letter Q, number 4. Adolescent and youth reproductive health guidance and counseling.
Section.
Kalagay dito sa Q. The elements of reproductive health care include the following: adolescent and youth reproductive health guidance and counseling. And adolescents start from the age of 10. So that was my question. They are going to get these instructions on IUDs and oral pills. Is that correct?
Well, it depends, Your Honor, on the age of the adolescent. Because the adolescent would range from 9 to 10 years old to, let us see. That has a definition, Your Honor.
Hanggang 17 yata itong adolescence.
It's 10 years to 19 years, Your Honor. So it should be age appropriate. You know, you don't teach IUDs and contraceptives to 10-year-old adolescents, Your Honor. It all depends on the particular age of the adolescent. That's why we have a range.
You will be surprised by the samples of teaching materials that are prepared for children of this age.
Well, I have seen samples of those, Your Honor. They are not sanctioned by the Department of Education.
Well, anyway, because it says there, no? They'll be taught about reproductive health, and reproductive health includes the use of all methods of preventing birth, according to you. So that will necessarily include contraceptives. Is that not so?
Yes, Your Honor, but it depends on the age of the adolescent.
I'm happy enough with that. So, well, suggestions often work on the immature mind. So those kids would probably believe this, what they're taught them, correct?
Your Honor.
From the age of 10, they will probably believe all of these.
Well, it all depends on the teachers who would be able to impart the particular age-appropriate information. But let me just place on record that sexuality education, as validated by the United Nations and progressive countries, have beneficent effects. One, it would inculcate to adolescents proper sexual values. Two, it would delay the entry into sexual relations. Third, it would avoid multiple sexual partners. Then it would also promote abstinence before marriage, and also it would prevent the transfer of sexually transmitted diseases. These are all very beneficent results of sexuality education in connection with the provision you are citing, Your Honor. And there is no contrary evidence to that to those findings.
Yes, okay. So just one last point. I'm just curious. For my reading, the law punishes all acts that tend to impede the distribution and use of all these methods we're talking about. Acts like providing incorrect information about reproductive health, that's punished. Refusal to insert copper IUDs in the woman's womb for doctors and health without valid reason. Refusal to extend quality health care services information on account of marital status, gender, age, religious convictions, personal circumstances or nature of work, or it also punishes official indifference to assigned tasks of public officials. But the law does not punish acts that violate a person's decision not to take part or take a limited part in the state's reproductive health program. For instance, the law does not punish manufacturers and distributors that sell drugs which function as abortifacients. It does not punish misleading those who may want contraceptives but reject abortion. The law does not punish those who provide contraceptive products to minors without the parents' written consent. The law does not punish those who provide guidance and counseling to adolescents without the knowledge and consent of their parents. The law does not hold manufacturers and distributors of artificial contraceptives liable for false claims and side effects that are not told to the user. You know, in the U.S., as I said, buyer had to pay about over $1 billion settlement because of false claims. And the law does not ensure recovery of damages against manufacturers. Not this law there's no protection, absolutely. Now, the law lacks the restrictions that will prevent pushing the adolescents and the young of the edge into the slippery slope of unrestrained sexual freedom that will hurt family values and public morals. Is this not a denial of the right to equal protection?
Your Honor, those supposed violations which you have mentioned are covered by existing law. They don't have to be repeated here in the RH law.
I have not found them in other
For
laws.
example, there are consumer laws which would cover those
In
incidents.
your memorandum, please show to us those
Yes, Your
laws
Honor,
that punish this.
including the Truth in Advertising Act would also include those violations. But let me just make this point very clear. With respect to minors, the provision of the law is clear that the access of minors to modern methods is not allowed without the written consent of parents or guardians unless the minor is already a parent or has a miscarriage. So if that is violated, then that is a penal sanction.
Oh, but you see, if you teach these young people, they say, oh, hindi nyo pa ito gagamitin, this is not available to you, you have to get your parents' consent to get them. But this is good for you. We have a recipe of things here that you can use. Hormonal contraceptives, IUDs of two kinds, etc. This will work for you in the future. You know, but you have to get parental consent because you are minors. You know, we prohibit the sale of liquor to minors. But does it ever work for us? When these things is made public, because this law places it in the essential drugs list, where even everybody will have access to it, you think it will prevent these children whom you have told that this thing will work for them, they can have sex without responsibility, will stop them from getting this? Thank you, Counsel.
Your Honor, I think we are working on a wrong premise that adolescents, including adults, are inherently promiscuous and would engage in irresponsible sex. I think that should not be the assumption, Your Honor.
But that's the experience of Europe and the US and other countries.
No, Your Honor, there has been no validation that the advent of contraceptives would increase promiscuity. As a matter of fact, promiscuity has antedated contraceptives.
Justice Mendoza.
In your statement, Congressman, you mentioned about the repealing clause. Can you repeat that because I may have gotten it wrong?
I beg your pardon, Your Honor.
Repealing clause, you mentioned about the repealing clause.
What I said, Your Honor, is that under the repealing clause, just to support the statement that the RH law has an anti-abortion policy, the repealing clause says that prevailing laws on abortion are not repealed, modified. And let me just quote the repealing clause just to be very accurate about it, Your Honor. Section 29, Your Honor, says, except for prevailing laws against abortion and any law, presidential decree or issuance, executive order, letter of instruction, administrative order, rule or regulation contrary to or inconsistent with the provisions of this Act, including Republic Act number 7392, otherwise known as the Midwifery Act, is hereby repealed, modified, or amended. But that repealing clause exclude prevailing laws against abortion, Your Honor.
Thank you. How about Republic Act 9710, Magna Carta of Women?
Magna Carta. The reproductive health law is complementary to the Magna Carta of Women.
So, the provisions on women's health are not repealed or
No.
abrogated.
No, Your Honor. But let me just impress that there are major differences between the RH law and the Magna Carta of Women. And may I just enumerate?
Yes.
One, the RH law provides for universal access to RH information, care, and supplies. Then the RH law mentions about the Philippine National Drug Formulary and essential medicines. The RH law provides for issues on infertility and how to procure infertility. It also provides for honorarium for barangay health workers. It provides for a congressional oversight committee. It provides for a liberal interpretation clause. It provides for prohibited acts. It also provides for the joint responsibility of national governments and LGUs in the implementation of the law. And the procurement and distribution of family planning supplies are based on empirical standards. And then there is the requirement of full range of family planning methods in government hospitals and accredited health facilities, and also an annual maternal death review, which are not provided for in the Magna Carta of Women. And for a historical annotation, Your Honor, many of those conferees who signed the Magna Carta of Women said in writing that they are agreeing to the Magna Carta of Women provided that Congress should pass a reproductive health law.
So Section 17 is retained. I will read part of it. That in the provision for comprehensive health services, due respect shall be accorded to women, to women's religious convictions, the rights of the spouses to found a family in accordance with their religious convictions, and the demands of responsible parenthood, and the right of women to protection from hazardous drugs, devices, interventions, and substances. These are retained.
Those are provided for in the Magna Carta of Women, Your Honor.
Yes.
They are retained. As a matter of fact, they are contained in the Declaration of Principles.
Yes. In the rights of the spouses to found a family in accordance with their religious convictions. What is your reading of this?
That is a constitutional prescription, Your Honor, and that is found in the Declaration of Principles, Section 2 of the Reproductive Health Law. We truly abide by that provision.
That's good. In the RH law, there is a provision that in case of conflict between the one who is undergoing a procedure and the decision of the husband, conflict between the decision of the one undergoing procedure and the husband, the decision of the one undergoing procedure, of the procedure prevails. Is that correct?
Yes, Your Honor. With respect to certain surgical intervention, for example, a woman wants to have a ligation and the husband opposes it. Under the law, the woman should be, the decision of the woman must prevail. It is her body. And a woman is not a woman if she does not control her body.
Is this not inconsistent with the Section 17 that the rights of the spouses to found a family in accordance with the religious conviction? Is this not consistent? You are disregarding the decision of the spouse, the husband.
Considering that there is a conflict between the spouses, Your Honor, I think the one undergoing the procedure should prevail. And I think these provisions can be harmonized.
Maybe if she is undergoing an emergency to save her life, but this is tubal ligation. Your example is tubal ligation.
Yes, Your Honor. Despite the fact that it is tubal ligation, it is not life-threatening. the woman should be able to, the decision of the woman to undergo such procedure should prevail. It is her body, and she should control her body.
I'll go to another point. The RH law, in your comment in intervention on page 52, you mentioned the RH law is replete with provisions upholding the freedom of religion and respecting religious convictions. Earlier, you affirmed this with qualifications. Now, you have read, I presume you have read the IRR, Implementing Rules and Regulations of the RH.
Yes, Your Honor, I have read, but I have to admit that it's a long IRR, and I have not thoroughly dissected the nuances of the provisions.
I will read to you one provision. It is section 5.24. This I cannot find in the RH law, but in the IRR it says, skilled health professionals such as provincial, city, or municipal health officers, chief of hospitals, head nurses, supervising midwives, among others, who by virtue of their office are specifically charged with the duty to implement the provisions of the RP-RH Act and DSUS, cannot be considered as conscientious objectors. Do you agree with this?
I will have to go over again the provisions, Your Honor.
In other words, public health officers, in contrast to the private practitioners who can be conscientious objectors, skilled health professionals cannot be considered conscientious objectors. Do you agree with this? Is this not against the constitutional right to the religious belief, to one's religious belief?
Your Honor, if there is any conflict between the IRR and the law must prevail.
Oh, thank you. You quoted in page 43 of your comment in intervention that during combined oral contraceptives, there may be changes in the endometrium. You mentioned, however, that there is no evidence that there is disruption of implantation. What do you mean by disruption of implantation?
Which means to say that there is a prevention of the fertilized ovum from being implanted in the uterus. Because although we considered that that could be a mechanism, which is third mechanism of action, until now, Your Honor, medical science has not validated that there is such a third mechanism of action.
So you are referring to the implantation, before implantation?
Yes, Your Honor.
You mentioned earlier that, or in your comment in intervention, that beginning of life is implantation. Am I correct? Am I?
Yes, Your Honor, but that is a personal opinion, and at the same time based on medical authorities. But as far as the law is concerned, there is no need to resolve that particular issue, and I think the Honorable Supreme Court can adjudicate the issues raised by the petition on constitutionality without in any way adjudicating that particular issue, because it could be in the domain of medical science and authorities.
But do you agree with, but are you aware of ectopic pregnancies?
Yes, Your Honor.
So,
as a matter of fact, ectopic pregnancies are being used as an argument against the third mechanism of action, because the fertilized ovum can even implant on a more hostile venue other than the mother's womb or the woman's uterus.
So you agree with me that that is proof or evidence that there is life before implantation?
Your Honor, the fertilized ovum may be a living organism, but it is not a human being, it is not a human person, because the personality of a human person is determined upon birth, which retroacts to conception, depending on whether the fetus, the child is born alive after complete detachment from the mother's womb, or if the life of the intrauterine life of the child is less than 7 months, then it has to be alive for 24 hours after birth. You know, I think this should all be.
But it must be alive. So it was alive before.
Well, Your Honor, after conception, there is life there already. That's why the Constitution says the state shall equally protect the life of the mother and the life of the unborn from conception. But Your Honor, you were saying about fertilized ovum.
Yes. Anyway, I will leave it at that. Just one more. Are there now certified contraceptives or contraceptives certified by the FDA?
Yes, Your Honor. As a matter of fact, the Philippine National Drug Formulary has been in existence. The reproductive health law simply institutionalizes the use of this National Drug Formulary. And under the National Drug Formulary, there are already contraceptives certified by the Food and Drug Administration as legitimate, safe, and effective.
And if these are proven, proven evidence-based argument that they are really abortifacients, can they be facially challenged now or subjected to a court case?
Yes, Your Honor. The FDA has been given the competence in a previous law creating the FDA to determine the legality and whether these are medically safe or not, these contraceptives. And this is reiterated in the reproductive health law, because under Section 10, the FDA is mandated to release guidelines on the use of contraceptives, particularly considering their effects.
Okay. So, in your page 48 of your comment and intervention, you mentioned, you stated that if it is subsequently ascertained that contraceptives prevent the implantation of the fertilized ovum, then under the RH law, the FDA can determine such secondary action as abortive.
Yes, sir. That is the definition of abortifacient under Section 4A, which is a formulation of the critics of the RH law, which we accepted.
So if the FDA determines such secondary action as abortive, can the FDA or will the FDA certify it as, or can it ban it?
Yes, Your Honor. If a device or drug is determined by the FDA to prevent the fertilized ovum from breaching or implanting in the mother's womb, then that is considered an abortifacient under the definition of Section 4A. Although, as of now, that has not been validated, and we would, the beauty of this law is it is even anticipatory of a possible third mechanism of action of contraceptives, which would be considered abortifacient.
Thank you very much, Congressman.
Thank you, Your Honor.
Justice Perez.
Just to make sure that I heard everything right in the past discussions, what is made criminal or is made punishable under the law is for a healthcare service provider intentionally providing incorrect information. When you say incorrect information, that is defined by what is correct information. And from the discussions we have had thus far, the determination of what is correct information has been delegated by the law to the FDA. In other words, at this point, we do not know yet what will be criminally punishable and what is not criminally possible, because the law itself does not define or confine or delineate what is correct information. It is yet forthcoming from the FDA, and if I heard you correctly a while ago, that cannot be really a determined fact at any point of time, because it will change as the FDA analyzes or is confronted with drugs that is presented to it for evaluation or for analysis. My point is that this law makes criminal what is an act which is yet undefined. Is there not something wrong with the law?
No, Your Honor. The law defines punishable acts which could be considered culpable at present.
And
because the FDA has already certified certain contraceptives as medically safe, legal, and effective. The Solicitor General last time, Your Honor, made a presentation of I think more than 50 contraceptives which were approved by the FDA. If a doctor would say knowingly a contrary view that these contraceptives are not safe, they are illegal, they are abortifacient, then he is amenable for prosecution under the law.
So, yes, it is the FDA which determines or which defines the crime.
No, Your Honor. The law defines the crime, and the FDA is the one which determines whether contraceptives are medically safe, legal, non-abortifacient.
The correctness or incorrectness of information depends upon what the FDA says is safe, legal, etc. And we have to accept that at this point, this law has not listed what the FDA has determined to be safe, legal, etc. In other words, at this point, the law is yet incomplete.
Now, Your Honor, the law is complete because the FDA has been in existence, contraceptives have been in existence, and the FDA has already certified that certain contraceptives are medically safe.
And that is not appended into the law, that listing of that safe contraceptives. And it can be, that list can be prolonged, or more can be added to the list. That list can be, items in that list can be deducted. Items in that list can be erased in accordance with the determination of the FDA at one particular time.
Precisely, Your Honor.
In other words, what is correct or incorrect will vary and will be determined by the FDA, not by the law, because the law says, FDA, you determine what is correct or incorrect. And you say that is already a complete and a correct delegation. Will you please discuss that? Why that is permissible under our system of laws?
Your Honor, the reproductive health law already made the standards under which the FDA will have to be guided. And because the FDA is the competent administrative agency which could determine whether these contraceptives are medically safe, effective, legal, and non-abortifacient in relation to Section 4A. So there's nothing wrong with the law. It is complete.
It is complete because the Congress, through this law, has already delegated to the FDA the function of defining what is criminal under this law.
No, Your Honor. What the Congress delegated to FDA is the determination whether contraceptives are legal, medically safe, effective, and non-abortifacient.
Okay. I will not prolong the discussion.
Justice Reyes.
Good afternoon, Congressman Lagman.
Good afternoon, Your Honor.
Section 12, Article 2 of the Constitution recognizes, among others, the sanctity of family life and shall protect and strengthen the family as a basic autonomous social institution. It shall equally protect the life of the mother and the life of unborn, not unborn child, from conception. Now, am I correct with my understanding that when the Constitution says that it shall protect the life of the unborn from conception, it does not say that from the moment the sperm and the egg shake hands, human life is already present. Am I correct?
The Constitution is silent on that, Your Honor. It's very clear that the Constitution said from conception.
And it is from the moment of fertilization, the ovum should be treated as life. Am I correct with my understanding?
The Constitution does not say that, Your Honor.
So it is the...
It says that the state shall equally protect the life of the mother and the life of the unborn from conception.
So when is the life of the unborn begins?
Well, if we have to read the Constitution, then it's from conception, because that is the time the unborn is protected. But as we have said, Your Honor, it is not really important to resolve that issue when life begins, because under the reproductive health law, the contraceptives principal function would be to inhibit ovulation or prevent the sperm from fertilizing the egg, in which case there is no fertilized ovum yet. But it extends its protection to the implantation of the fertilized ovum. So it would not be necessary anymore whether when life begins should be determined. I strongly suggest that the issues on constitutionality raised by the petitions can be resolved without adjudicating that issue on when life begins, which is more in the domain of medical science. That's why the Constitution did not even say when life begins.
But when the life was expelled from the mother's womb, there is a felony of abortion.
Yes, Your Honor, because once the fertilized ovum implants on the mother's womb, then conception begins or pregnancy begins. And it is only upon implantation of the fertilized ovum that pregnancy can be detected. There is a test for pregnancy after implantation, but there is no test for fertilization.
Because the unborn is already a separate body from the mother's womb. Am I right to state that? Because there is life, but there is no personality yet.
Yes,
that's what the Constitution says unborn. It does not say unborn child.
Yes, Your Honor. And I think there is reason for that. Because the unborn at that moment may not be a child, but is still unborn, and it has from conception, it has to be protected. And according to the Civil Code, it will get all favorable things from conception once it is born alive.
Does any direct killing of the unborn from the moment of conception would be against our Constitution? That
Yes.
is my understanding.
Yes, Your Honor.
And am I right or correct to say that contraceptives are preventive in nature and character, as there is no unborn yet? Is that a correct statement?
Yes, Your Honor. It's
Mr. Congressman?
it prevents fertilization because it inhibits ovulation. If there are no eggs produced, then there can be no fertilization. And even if there are eggs produced, if the sperm is inhibited or prevented from fertilizing the egg, then there is no fertilization. In other words, Your Honor, the principal action of contraceptives prior to fertilization would be completely legal, and because there is no unborn to be protected at that moment.
That preventive pregnancy can still be covered under what we call population control policy.
Well, Your Honor, we have said in the law that the reproductive health law is not a population control policy. It has no demographic targets. It does not fix any population growth rate. And the central idea in the reproductive health law is freedom of informed choice. And if there is freedom of informed choice, there can be no population control.
All right. Would you agree with me, Mr. Congressman, that Section 4 of Republic Act 10354, which defines abortifacient as any drug or device that induces abortion or the destruction of a fetus inside the mother's womb, or the prevention of the fertilized ovum to reach and be implanted in the mother's womb, is the destruction of the unborn and is therefore illegal and unconstitutional?
Well,
is that a precise statement or understanding of that particular section of the law, Mr. Congressman?
I think the definition, Your Honor, can be divided into two. One is the traditional meaning of abortifacient, which is the use of this drug or device would result to the expulsion of the fetus or embryo from the mother's womb before it becomes viable. That's the first part. The second part is an innovative definition of abortifacient, because it would encompass drugs and devices which would prevent the implantation of the fertilized ovum in the mother's womb. And the destruction of that fertilized ovum is virtually a prevention of its implantation. Because if it is destroyed, then it cannot be implanted. But this is a third mechanism of action which we would hasten to say is not yet medically validated. But we acceded to that proposition as a concession to the critics of the RH bill. And we are leaving the determination of the third mechanism of action to the Food and Drugs Administration.
So based on your disposition, it would be right for me to assume that the constitutional intent to prohibit the passage of abortion statute and not the contraceptive statute like this RH bill.
One of the very important arguments to show that the RH law is against abortion is the definition provided for in Section 4A. It really gives protection to the fertilized ovum even before it becomes a fetus or an embryo. I think we are the only country in the world at the moment which has this innovative definition of abortifacient. But if we will have to err in favor of protection of the unborn, then we must. And that is a protection of the unborn.
Now, would you agree with me, Mr. Congressman, that at the moment we are almost 100 million in terms of population?
Yes, Your Honor.
And per NEDA data, there are more than about 50%, more than 50% of the populations belongs to the poor and the underprivileged families.
Yes, Your Honor.
And out of more than 50% of that population, about 28% of which belongs also to a level which is even below the poverty line.
Yes, Your Honor.
That when Congress envisioned this RH bill law more than 10 years ago, this is about almost 13 years ago, as you said, it had in mind foremost the plight of the poor families.
Among others, Your
Among
Honor.
others.
Among others, Your Honor.
And that statistics-wise, these families who belong to the poorest strata in our society have more children than like us, who are educated and who at least belong to the above middle class, medium middle class, light middle class, and the average class. Would you agree with me?
That is perfectly correct statement, Your Honor.
And in enacting this law, you also consider the provision in our Constitution about the Equal Protection Clause.
Yes, Your
Because
Honor.
there could be some basic violations you might commit in enacting that particular law. Am I correct to state that?
We have not transgressed, Your Honor, in enacting the law.
No, I'm not saying that, but you consider
Yeah, we did consider.
the Equal Protection Clause of
We
the
did consider,
Constitution.
Your Honor. We did consider.
That under the Equal Protection Clause of the Constitution, it does not require the universal applications of the law on all persons or things without distinctions.
If there is a proper distinction, then there is no breach of the Equal Protection Clause.
So you are saying is there is a appropriate or proper distinctions.
Yes, Your Honor.
Am I correct to assume that you are referring to the status of the various families, meaning to say that distinctions between the very poor and the underprivileged and those who belong to the affluent and the middle classes of our society.
Yes, Your Honor.
Would you consider that as
the differences among the
differences?
different quintiles?
Now, many proponents of the anti-RH law consider the downsizing, to downsize our population. Is that accurate?
No, Your Honor. No, Your Honor.
No, the
because
proponent
that
of
would
the anti-RH law.
Yeah, because as far as the RH advocates are concerned, the proponents of the law, we are not having any demographic target or downsizing of the population, because the mitigation or the stabilization or even promotion of population growth would be a result of the promotion of reproductive health, and that is provided for in the law.
So do I get you right, Mr. Congressman, that the proponents of the RH law are not very particular about the current increase in the populations of our country?
Well, we assume, Your Honor, that if we give women and couples the opportunity to exercise their basic human right to responsibly and freely determine the number of spacing of their children, then there would be a deceleration of the population, not as an objective, but as a result of promoting reproductive health. Because surveys after surveys would show that women, particularly those in the marginalized and disadvantaged classes, would prefer less children or not to have any more additional children. But they don't have access, Your Honor, to reproductive health information, services, and supplies. And that is why we have envisioned this law in order to really remedy that gap on the contraceptive needs of our people, particularly the poor women.
What can you say about the proponents of the anti-RH bill, that instead of pouring billions of pesos for contraceptives, the government instead utilizes its resources in promoting the health, the education, and etc. of the population? What do you say about that?
That is a very contrived and unwarranted proposition, Your Honor. Because first, the RH law does not in any manner deny governments appropriating for other basic services like health, education, employment, and the environment. No. Because this law is really only on reproductive health and responsible parenthood. Number two, that argument fails to consider that the promotion of reproductive health and family planning is very cost effective. It does not need mega millions to be appropriated in order to achieve benefits for so many people, Your Honor. That's why we have quoted the UNICEF when it said that reproductive health would bring more benefits to more people at less cost. That is true, Your Honor. The studies would show that government is spending about 5.5 billion pesos annually for medical assistance as a result of high-risk pregnancies and maternal and infant morbidity. But the government will only use about 3 to 3.5 billion pesos in order to promote reproductive health and family planning. So there would be even a saving on the part of government, which savings could be used to augment services like education, health, and other requirements of the country. It is really cost effective, Your Honor. We don't spend mega millions for the promotion of family planning and reproductive health.
Would you agree with me that if the poverty level is only about 1%, 2%, or even up to 10%, it would be the disposition or the proponents of the anti-RH bill is correct when instead of spending billions for the contraceptives, it would devote much of its efforts in the health, in seeing to it that the health, the education, etc. of the people would be given time by the government.
Yeah, yes, Your Honor. That could be true if we don't have a problem on poverty and poverty alleviation. But even if we don't have that problem, it is still necessary that a reproductive health law should be enacted and implemented, because it really would promote further the health of women and infants, and as well as reduce the incidence of abortion.
All right, thank you, Mr. Congressman.
Thank you, Your Honor.
Justice Leonen.
Good afternoon, Congressman.
Yes, sir.
Am I right to assume that you must have imagined that while you were defending this bill as principal sponsor in the floor of the House of Representatives, that you would one day appear before us on the same topic?
Yes, Your Honor. From the very start of our debates, we anticipated that the bill, if enacted into law, would be challenged before the Supreme Court.
So would it be presumptuous on our part to say that it was not only you, but the other sponsors of this bill, as well as those who were debating against the propositions, that knew that someday we would be here in the Supreme Court?
Definitely, Your Honor, that was our expectation. And that's why even during the debates, we extensively discussed constitutional issues.
May I know what was the voting of the House of Representatives on second reading on the bill?
I think, if I remember right, on second voting, the bill was approved by a margin of 9 votes.
By a margin of 9 votes.
9 votes.
And on third reading, was the vote the same?
No, Your Honor. On third reading, it was a wider margin. I think it's more than 50 or so. 50
votes. And may I know what changed between the second reading and the third reading?
Well, Your Honor, it was a realization that, one, there is really a need for the passage of the reproductive health law on the part of those who were still ambivalent. And also, the bill was certified by the President as urgent, and most probably that gave a push for the wider margin in favor of the bill. But I would like to underscore that the certification of the President came after the RH advocates won on second reading.
So I am also, we can be also right to assume that apart from your reading of the Constitution, the representatives in the House of Representatives we're also considering other factors, such as, for instance, your political futures, that many of you were going to go for re-election for their various districts, as well as a matter of fact, the media, who would project each argument that was made on the floor.
Your Honor, during the debates, we circulated the consistent survey that the electorate would vote for candidates who have an agenda on family planning and reproductive health, and that 75% of the voters would vote for candidates who are willing to spend public money for contraceptive use and who are willing to have sexuality education enforced by government. So our colleagues were fully aware of the sentiments of our people, and we coupled this survey with various surveys nationwide, region-wide, and district-wide, which would authenticate that the people are really clamoring for the passage of the RH law, including its salient provisions.
So, unlike this specific forum that we have today in the Supreme Court, there were about 200 plus of the members of the House of Representatives discussing with each other, forming political coalitions on this bill, debating with each other almost on a daily basis during the time that it was in second reading. And the back of your minds was not only the Constitution, but also what you felt were going to be the views of your constituents. Am I correct in this?
Yes, Your Honor. And we took the position that our constituents would endorse the approval of the bill. Many of us went to our districts and made surveys, and we felt the pulse of the people, majority of whom are Catholics, and they resoundingly endorsed the enactment of this bill. So we were consistent with the wishes of our constituents.
Yet, in our hands lies the ability to declare this entire law as null and void ab initio, and therefore the effect, rightly or wrongly, just the effect, counsel, would be to erase what had happened. Is that not correct?
Well, we hope it will not happen, but that the Supreme Court has the power to nullify this law, and in the process, we feel that the clamor of the constituents, the decision of the two political departments would be overruled by the court.
But that power is lodged on us by the constitutional order on the basis of our ability to be able to find judicially determinable standards or principles or value embedded in the Constitution. Is that not correct?
Yes, correct. That's how the power of judicial review is circumscribed.
Yes, and what I know is that our power is circumscribed only by us, and in many of our jurisprudence we have said that that principle or value must be very clearly stated and very convincingly violated, at least at bar, when a case is presented before us. Am I not correct?
Yes, Your Honor. There must be a very clear case of a violation of the fundamental law in order to declare a statute unconstitutional.
By the way, has this law been implemented?
Well, there was this, before the implementation started, there was the status quo ante order issued by the court, which has been extended indefinitely, and the law has not been implemented.
So, as a matter of fact, we will not be able to see yet whether the words in the Constitution, the words in the statute, will be interpreted this way or that way by the administration for instance, the FDA or the Department of Health, because it has not yet been implemented. Is that not correct?
That's correct, Your Honor.
In your experience, because I know you, Congressman Lagman, I know your history as a lawyer, at the same time as a member of Congress, as a legislator, in fact as a leader of the legislature, in fact also a minority leader. In your experience, have there been instances when Congress has perfectly came out with words such that there can be no other interpretation except the interpretation that you wanted it to be? Or are words in statutes, even the Constitution, inherently there are differing interpretations of some of the words in statutes?
Well, generally, statutes would convey the intention of the legislature in the very phraseology of the law. And we feel, Your Honor, that in this particular statute, the reproductive health law, we have endeavored and succeeded to have the phraseology of the law consistent with the intention of the legislators of Congress.
As a matter of fact, the default standing of this court must be to allow you to have that discretion. Is that not correct?
Yes, Your Honor.
And in fact, we cannot interfere with that discretion unless there is, in the words of the Constitution, grave abuse of discretion. And I think it's a very redundant term if not looked in a technical sense. Not only must it be abuse of discretion, it must also be grave abuse of discretion. Counsel, may I know what your thinking is on this particular point?
Well, as far as the requirement of grave abuse of discretion, we submit that the Congress did not commit any grave abuse of discretion. And we have fully ventilated the issues, and we have resolved the conflict between the between the proponents and the critics in a very civil and procedural and substantive manner, that we have enacted a law which would address both the concerns of the proponents as well as the reservations of the critics of the law.
And that discretion also applies to the evil that you want to prevent as Congress, and of course, when the President approves your bill into law, the evil as well as the means to address that evil. So for instance, Counsel, when you decided that to address the maternal deaths, the numbers of maternal deaths existing out there, that discretion is entirely yours and is not within the province of the judiciary. Am I correct to assume that?
Well, yes, Your Honor, we claim that discretion is vested on the legislature.
Therefore, when you gave priority to maternal deaths, rather than, for instance, cholera and malaria, assuming for the sake of argument that there is still no law on malaria and cholera, assuming only for the sake of argument, that discretion cannot be touched by the judiciary. Is that not correct?
Yes, Your Honor, because that goes into the wisdom of the statute, and the wisdom of the statute is not subject to judicial review.
And when you said a while ago, if I'm not mistaken, that 1/3 of all maternal deaths can be prevented by mere contraception, that finding also is not within the province of the judiciary, but we should allow Congress, acting as a whole, this by the House of Representatives and also by the Senate, and with the President, with all his advisors, to determine that that is, in fact, a fair and, shall we say, a reasonable determination on your part.
Yes, Your Honor, because we receive evidence and facts before we made that determination.
Absent clear, grave abuse of discretion, which means that it has no basis in science whatsoever, no evidence, no science to support it, then are you saying that it is binding on this court? That is a good way to prevent maternal deaths. That is, by the use of contraception, 1/3 of all maternal deaths can be reduced.
Well, the determination, I submit, Your Honor, that the reproductive health law would prevent 1/3 incidence of maternal health with medically safe, legal, effective, and non-abortive patient reproductive health and family planning services and products would be the domain of the legislature, and also as approved by the executive. So the two political departments wherein representatives of the people are present have made that determination already.
Again, Counsel, I know from your experience being with Congress and as a practicing lawyer, perhaps also addressing the many needs of the administration and this court in terms of budget hearings and all of that. Why is it that it is Congress that should have that ability and not this court?
Well, Your Honor, the Congress has the wherewithal of determining these particular priorities with respect to which should be legislated and budgeted. Because this also involves the budget, and the power of the purse belongs to Congress.
And your determination of the facts is not as strict as the determination of facts in court. Is that not correct?
Yes, Your Honor.
Let us go to another topic, and this is the right to life, which is also your topic, Counsel. You mentioned the existence of Article 2, Section 12, and that I think that it reads, it shall equally protect the life of the mother and the unborn from conception. Is that not correct?
That's correct, Your Honor.
Now, of course, there are a lot of imponderables in that statement. One, of course, is what is meant by equally protect. Counsel, would you know of this term therapeutic abortion?
Yes, Your Honor.
And in cases of therapeutic abortion, there are instances when it is the implanted fetus that needs to be let go, or it is the fertilized ovum, if it is blighted, that should be let go. Is that not correct?
Yes, Your Honor.
But at this point, does this law actually compel us now, with the words in the statute and with the petitions that were filed with us, for us to actually determine when conception actually is?
As we have submitted earlier, Your Honor, it is not necessary for this honorable court to adjudicate that particular question in order to resolve the issues of constitutionality raised by the petitioners.
You mentioned a while ago that the law defines abortifacient, but it does not define abortion. Why is that so, Counsel?
Well, Your Honor, because the law is very specific already on having anti-abortion policy, and that abortion has a well-defined medical and legal meaning, which is the expulsion of the embryo or fetus from the mother's womb before it becomes viable. That is a standard definition, Your Honor. And there is no need to reiterate such definition.
And when the constitutional commissioners wrote that phrase, equally protect the life of the mother and the unborn from conception, in fact, when the people ratified the Constitution, wouldn't you say that it was also aware that there are instances when these dilemmas would have to come forward and be decided upon by law and, in fact, by a court of law at some point?
Yes, Your Honor.
Why is it that we cannot decide it now when we want to? Counsel?
Well, Your Honor, because the reproductive health law as enacted is well within the confines of the Constitution, And we have not violated any particular provision of the Constitution, even that provision on the equal protection, that the state shall equally protect the life of the mother and the unborn from conception. We have addressed that problem, and we are consistent with that provision. We uphold that provision, and definitely the reproductive health law has not infringed on any particular provision of the Constitution. That's why we are beseeching the Honorable Court that, like the political departments which have clearly approved this measure, like the Filipino public, majority of whom are Catholics, who have clamored for the enactment of this law, we hope that the Supreme Court would also sustain the constitutionality of this law.
And we cannot rule upon it unless it is a case itself, an actual case, because the judicial temperament is supposed to be one which does not only provide advice, because we cannot provide advisory opinions, we cannot decide on theory, but we must have the actual facts before us in order to frame the issues as well as the modalities of interpretation of both the statute and the Constitution that we have. Isn't that correct, Counsel?
Yes, Your Honor.
Yes. Let's go to the continue with the right to life. Would you agree with me that the right to life is not only the right to existence, but also to a certain quality of life in our present Constitution?
Yes, Your Honor, but when we say quality of life, we're not anymore talking about the unborn. We are talking of the millions, the multitude of those who are already born and living.
But there are relationships, is it not, Counsel? For if there are too many children to a couple or to a person who might be a single parent, but that single parent may not have the wherewithal to provide for all of them, then certainly there are effects of his material existence on the quality of life of the children. Is that not correct?
Yes, Your Honor.
And the government cannot simply stand idly by watching that happen, and therefore government must provide for a situation where that can be prevented, or if not, if it actually happens, that the children are provided for and the families are able to provide a good quality of life. Is that not correct?
Yes, Your Honor. That is why one of the compelling reasons for the enactment of this law is that we will have to address this ballooning population, which impacts adversely on all major human development indicators like education, health, food security, mass housing, employment, and even the environment.
Thus, Article 2, Section 12 must be taken in an entire context of the entire Constitution. Is that not correct?
Yes, Your Honor.
Which means Section 11, which provides for human dignity, Section 10, Article 2, which provides for social justice in all phases of life, Section 14, which provides for fundamental equalities between men and women, Section 9, which provides for government inducing rising standards of living, Section 15, which says the right to health, and Section 17, one of my personal favorites, total human liberation. So, it is not only the existence that is in question, but what kind of existence under the Constitution. Is that not correct?
Yes, Your Honor.
Yes. And in this regard, it is the Congress and the President as political agencies that will decide how government is going to provide for it rather than this court. Is that not correct?
That's correct, Your Honor.
All we can say would be whether the decisions on programs, and in fact the law as it is applied, violates a fundamental principle in the Constitution. Is that not correct?
That's correct, Your Honor.
And we have to be careful about it because we trump the political departments whenever we declare that a certain law or any of its provisions are unconstitutional. Is that not correct?
That's correct, Your Honor.
Would you say, Counsel, that each and every provision in this law has been fought for, bargained for, compromised during the political deliberations?
Yes, Your Honor, and all of them are consistent with the Constitution.
Yes. Just for purposes of the record, and perhaps you can also cover it in the memorandum, but if you know, during the bicameral, how many points of contentions were there between the Senate and the House?
Well, generally, there was unanimity between the House and the Senate panel on major provisions like the universal access to reproductive health information, care services, and commodities, provided these are not abortifacient and would not prevent the implantation of the fertilized ovum in the woman's womb. There was unanimity on reproductive health education. There was unanimity on the Philippine National Drug Formulary, except that there should be no certification of approval for drugs or devices which are considered to be abortifacient or not medically safe. There was also unanimity in on the question of the Department of Health being the lead agency in the implementation of the law. There were certain problems with respect to the role of the LGUs in the national government. But this was resolved in favor of a joint responsibility in the implementation of the law, with the national government being mandated to give budgetary and financial assistance to local government units in the implementation of the law.
Thank you, Counsel. Let's go to another point, and this is part of your presentation and argument, and this is on the legislative intent. Would we be correct in saying that the legislative intent of Congress is not determined by what the principal sponsors say in public, but how the law is actually worded?
Yes, Your Honor.
And by the law being worded, it is not by isolating phrases in the law, but taking it in its overall context. Is that not right?
Yes, Your Honor. And that is a general prescription with respect to the construction of the statutes, that they should be read as a whole and not by individual provisions.
Let us go to Section 9, for instance, something which was discussed a while ago. And the provision there has this portion relating to shall include hormonal contraceptives, intrauterine devices, injectables. So the National Drug Formulary, taking that phrase alone, actually that provision seems to say that it includes already hormonal contraceptives, intrauterine devices, injectables. However, if we continue on and read the entire sentence, it does say and other safe, legal, non-abortifacient, and effective family planning products and supplies. There is the words there, the words there, safe, legal, non-abortifacient. Does that only qualify the word other, or does that also qualify hormonal contraceptives, intrauterine devices, and injectables?
The antecedent would include hormonal contraceptives, intrauterine devices, injectables, because all of them should be safe, legal, non-abortifacient, and effective as determined by the appropriate government administrative agency, which is the Food and Drug Administration.
So because it's in one entire statement, therefore redondo, singula, singulis will apply, which means that we apply all the adjectives to all the nouns that come before it. Is that not correct?
That's correct, Your Honor.
So therefore, we can say that there are hormonal contraceptives which may not be allowed by the FDA.
Yes, Your Honor.
But there are hormonal contraceptives which may be allowed.
Yes, Your Honor.
Did Congress actually say that all hormonal contraceptives are therefore safe and therefore allowed?
We did not say that, Your Honor.
Okay.
We did not have the competence to say that. That's why we devolved to the Food and Drug Administration the authority to make such determination.
Again, on intent, counsel, Section 23, subparagraph A, number 1, where the word incorrect exists. And, looking at the phrase, provide incorrect information scares all of us. Provides incorrect information because it seems to imply that the government has a monopoly of correct information. However, first let me ask you this question. When a doctor prescribes to a diabetic soft drinks, is it something that should be frowned upon, proscribed, and even punished?
Yes, Your Honor.
Because
it would be deleterious to the health of the patient.
As a matter of fact, when a doctor prescribes or says that it is all right to smoke to a person who has already lung cancer or throat cancer, that too is something which is mischievous, should be proscribed. In fact, given that it is very negligent, it should be punished with penalties as well as civil liabilities. Is that not correct?
Yes, Your Honor. That is in the nature of an incorrect information.
Can we take letter A? Any healthcare service provider, whether public or private. It does not say anybody. It just simply says healthcare service provider that provides incorrect information. These are the people that are going to be punished. Is that not correct?
Yes, Your Honor. It is a definite class of people. These are the service providers.
In other words, we are saying that we are not only looking at the particular provision, the particular phrase isolated, but we should look at the entire context of the entire law. Is that not correct?
Yes, Your Honor.
This should be the attitude of our courts. Is that not correct?
Yes, Your Honor.
Or should we presume that there is something sinister or unconstitutional about these provisions?
Being sinister or unconstitutional is never presumed, Your Honor. The
Yes.
opposite is presumed.
Okay. Let me go to one other point, and perhaps you might be the best person to address this. You were asked a while ago whether there was a preferential treatment in this law for the poor. Is there a preferential treatment for the poor in this law?
Well, Your Honor, the intention of the law is to make beneficiaries of this law, voluntary beneficiaries, more from the ranks of the poor and the underprivileged, because they are the ones who do not have access to reproductive health information, services, and supplies. And moreover, they are the ones who need such information and supplies, because with respect to those who are well off, they have their own means of accessing contraceptives and reproductive health information. And the data would show, Your Honor, that it is in the lowest quintile, where there are so many children. The average is still about 5.5 per woman, which is the average total fertility rate 40 years ago. And that's why that is a compelling reason which the Congress should be able to address and remedy.
At the risk of repetition, because you did say this during your oral arguments, just so I am also clear about it, access does not mean use. Is that not correct? Access does not mean use.
Yeah. Well, we can start from the proposition that availability is not access.
Meaning to say?
And access may not be equivalent to use.
That the crux of this law is to provide the data, the information, the technology, make the information available. But is it true that this law compels the poor to use a condom, compels them to use an IUD, a copper IUD, compels them to use a dangerous hormonal contraceptive?
No, Your Honor. central to the law is freedom of informed choice, and I could point out now or in the memorandum the different provisions which would provide for informed choice and respect the choice of couples and women.
Perhaps in the memoranda that the councils are going to submit, because I surmise that even the petitioners are going to have their own interpretation of several portions of this law. Maybe a last series of questions. And I do this only because I know that you have been a human rights advocate, and your family has suffered a lot in terms of human rights violations, the disappeared as well as an assassination of a brother. And if I may ask you this, genocide was mentioned in terms of this particular law, that this particular law was targeting the births of the poor and reducing them because they are poor. Do you agree that this is a law on genocide?
No, Your Honor. That is an aberration of a conclusion or a appreciation of the law.
As a matter of fact, genocide as properly defined in specific treaties must be addressed particularly at a particular race, ethnicity, or religion. Is that not correct?
That's correct, Your Honor.
And that is for the purpose of actually wiping them out. Is that not correct?
Yes, Your Honor.
So is this law for the purpose of wiping out the poor or helping them achieve a quality of life that Congress may have determined possible if this particular law was there?
It's really to uplift the quality of life of the poor. And it is not even anti-natalist, because the law provides that the poor is not deprived of having children because of economic reasons.
Thank you, Counsel.
I will just want to clarify one provision because it confuses me. Section 23, paragraph E, Counsel.
23, Your Honor.
Yes.
Paragraph
E.
E.
This is among the acts that are prohibited and is punishable. Can you read it for me, please? Because I want to check if I have the correct version of the law.
Is it any pharmaceutical company, whether domestic or multinational, or its agents or distributors, which directly or indirectly colludes with government officials, whether appointed or elected, in the distribution, procurement, and or sale by the national government and LGUs of modern family planning supplies, products, and devices.
Collusion for what, Counsel? There seems to be a verb lacking here. Collusion to what? Colluding to do what?
It's a collusion to favor the procurement and distribution of national products which is not above board. Well, it's not there, but that is the purpose.
That's the purpose. So there is something missing here.
Yeah, yes, Your Honor.
Okay.
I can give a history of this provision.
Okay, can you tell us?
The critics of the RH law had been saying that the RH advocates were being funded by pharmaceutical companies, which was completely unwarranted and not true. So, as a reaction to that particular tirade, we made sure that pharmaceutical companies who might be errant in the procurement and distribution of reproductive health products will be punished accordingly.
So this is vague because we really don't know what the collusion refers to.
Well, it says here, Your Honor, which directly or indirectly colludes with government officials, whether appointed or elected, in the distribution, procurement, and or sale by the national
maybe
government.
in the illegal or, as you were saying, not above board, distribution, sale, or anything.
It's not there, Your Honor, but that
It is not there.
It's the intention. really,
that's
because the collusion here would be in a negative.
But because this has a penalty clause, we cannot understand what the collusion is all about. As presently phrased, we cannot understand what the collusion is all about. Will you agree with me, Counsel?
Well,
that the specific act being whether we use connivance, whether we use collusion, whether we use the word cooperation, whether we use the word conspiracy, because there is no adjective that describes the nature of the sale, distribution, procurement of the goods and the services, there really is no illegal act that is clearly punished here.
Well, we agree, Your Honor, that there is some bigness in the provision.
And this is a penal clause.
Yes, Your Honor.
Okay. So with that, you are discharged, Counsel. Okay. Justice Mendoza has one last question.
Congressman, this was covered already in the last hearing, but since you are the principal author of the law, I would like to ask these questions. The petitioners have argued that the provision, praise any violation thereof of the law is vague, and therefore the RH law should be declared as void for vagueness. That is their argument. This was earlier asked in the last hearing, but the main justification or reasoning was that this is the same as in several laws before. What can you say about it?
Well, it's really a catch-all provision to encompass all violations of the law. But this should not be taken without any reference to the act or omission committed. And we feel that any culpability should depend on the evidence submitted by the prosecution on this particular matter.
Now, you mentioned, or in reply to you agreed with the Justice Leonen that if the service providers give incorrect information, they will be liable under this law.
Well, under this law, if they knowingly provide incorrect information,
yes,
they can be culpable.
And administratively.
Yes, they can be culpable, Your Honor.
Suppose it is the other way around. The FDA, they know this is. I'm just because there has been reports from Mayo Clinic that some contraceptives have caused cancer, breast cancer. Now, if this is validated and the FDA still certifies that this is a good drug, are they not punishable under this law, RH law?
No, Your Honor, because what is mentioned is that some contraceptives might increase the risk of cancer.
Yes.
But it does not categorically say that these contraceptives will result to cancer and would result to the death of the one using it. That is why the WHO, despite the research of one of its offices on the risk, would still include contraceptives in the essential, in the model list of essential medicine. And we feel, Your Honor, that it's a question of weighing the risk versus the benefits. And with respect to contraceptives, there are more benefits than risks.
But this is just conjectural. If it is really proven, there is evidence that they cause breast cancer, and still the FDA people, to satisfy the pharmaceutical companies, they collude with them, and still they do not ban these substances. Are they liable?
Well, if there is empirical and substantial evidence that some contraceptives would cause cancer, not really heighten the risk, but cause cancer, and the WHO would even delist these contraceptives from its list of essential medicine, then a defiance by the
FDA?
Drug Administration could lead to a prosecution for violation of the law.
Under this law?
Yes, Your Honor.
Thank you very much.
Because it takes both ways, Your Honor.
Thank you very much, Congressman.
Congressman Lagman, thank you. You are excused.
Thank you, Your Honors.
Next to argue is Senator Cayetano.
Your Honor, may I be allowed to use a PowerPoint?
See, please.
Thank you. May I begin? Only 15 mothers die. Madam Chief Justice, Honorable Justices, that is the statement of the petitioners on why the reproductive health law is unconstitutional. According to petitioners, the problem of maternal death pales in comparison with the number of deaths associated with serious illnesses. And so, to the petitioner, the stories of these women do not matter. Anna has 8 children. Her youngest is 6 months old. She did not want to get pregnant again, but she felt she could not deny her husband. And so, before her baby turned 1, she found herself pregnant. It was a complicated pregnancy. She needed bed rest, but with 8 kids to look after, she could not stay in bed. One day, she just collapsed and started bleeding. Anna and her baby died, leaving behind a husband and 8 motherless children. This is Maria. She was pregnant and suffering from hypertension. She delivered prematurely at 5 months, but her baby died. Just a year later, she became pregnant again. Once more, she delivered prematurely and sadly lost this baby too. The doctor told her it would be too risky for her to get pregnant again. But within 6 months, she was pregnant. This time, Maria died along with her baby. Lourdes, she feeds her baby brown sugar in water. She has 7 other children. They eat once a day. 3 of them eat in the morning, the other 4 at night. She is pregnant again, and she knows she has no means to feed another child. A heartbroken Lourdes was forced to give away her 3 children. To petitioners, the lives of these women do not matter. As a consequence, the lives of these children do not matter either. They are only a very small statistic as far as petitioners are concerned. But these are real women, These are real Filipinas who have faced the very real dangers and challenges that mothers all over the country face every day. They are pressing problems that the reproductive health law seeks to address. Madam Chief Justice, Justices of this Honorable Court, I stand here today not only as intervener and sponsor of the reproductive health law, but also as a woman, as a mother, and the voice of millions of women who died during childbirth and the families they have left behind. I stand here today as the voice of mothers and fathers who desperately seek to plan their families in order to provide for the children they already have or intend to have. No mother should have to give away her child. No mother should have to make the choice between terminating a pregnancy or being able to feed her children. No woman should die giving life. Petitioners are quick to defend the right of the unborn and even the potential of life. They are quick to ask government to spend funds for other health issues that plague the nation. Dengue kills some 1,000 people a year. Malaria, 63. And yet, when it comes to women, which claim 15 lives a day or over 5,000 lives a year, it is easy for them to look away, to raise all the objections of giving her access to services and the information she needs to have a safe delivery and to give birth to a healthy child. Why? Why is it so difficult to give women the right to health? Why can't we be given the benefit of life? Is it because the road to a safe pregnancy and childbirth includes the empowerment of women? Or is it because of petitioners' malicious view of women, as shown in their petition, where they say that the reproductive health law discriminates against husbands and fathers because it allows their wives to have pleasurable sexual experiences with other men without getting pregnant? This is how low petitioners view us women. Whatever the reason, the fact remains, for centuries, women have had little control over their pregnancies, which lead to maternal deaths and complication. Thus, Congress has decided that 15 mothers dying, teen pregnancies, malnourished and sickly children born to mothers who did not have access to reproductive health services, women who die from reproductive health-related illnesses, are reason enough for the reproductive health law. The basis is no other than the Constitution. Article 2, Section 12, and all other related provisions call to the urgency of the reproductive health law. Article 2, Section 12 states, "The state shall equally protect the life of the mother and the life of the unborn from conception." On the health hazards and availability of contraceptives, in support of their anti-RH stand, petitioners attack the safety of contraceptives, harping on its possible side effects. They choose to ignore the fact that all medicines, whether preventive or curative, have some type of side effect. No medicine is 100% side effect free. Following petitioners' logic, should we now eradicate vaccination due to its side effects? Do we now ban all drugs because of their side effects? Suffice it to say, the safety and efficacy of contraceptive has passed the scientific scrutiny of the most stringent drug regulatory agencies like the World Health Organization, and is supported by prestigious universities and organizations such as Harvard University, Johns Hopkins University, and the Mayo Clinic. And then petitioners question the inclusion of various family planning products as part of essential medicines, claiming pregnancy is not an illness. First, allow me to define reproductive health. Section 4P of the law defines it as the state of complete physical, mental, and social well-being, and not merely the absence of disease or infirmity in all matters relating to the reproductive system and to its functions and processes. With that in mind, let me state that indeed, pregnancy is not an illness, but it is a special condition that requires medical attention. And the degree of medical attention needed varies from one woman to the next. Why must it be included in the essential drug list? Because local governments and public hospitals can only purchase medicines that are on that list. In any case, if petitioner did their research, they would know that contraceptives in general have been included in the essential drug list for many years, even before the reproductive health bill was being discussed. Thus, we simply institutionalized an already existing practice. Petitioner would make it appear that women will be forced to use contraceptives against their will. Suffice it to say that sections 2, 3A, E, F, and H make it very clear that everyone has a free choice on this matter, and no one will be coerced into using any type of contraceptive. The law cannot be any clearer than that. As to the claim that the enumeration of certain family planning products in Section 9 as part of the essential medicine is a predetermination by Congress that all contraceptives are safe and are not abortifacients, let me clarify. The list is a general enumeration of the type of family planning products already included by the FDA and the WHO in its essential list of medicines. They have been determined to be safe and effective and non-abortifacients. This does not in any way preclude the FDA from doing its job and making a determination that a particular brand is substandard, ineffective, unsafe, or works in a way that is different from what is declared. Congress never intended to arrogate upon itself the power to determine pharmacological facts, and neither should this court. That is the duty of the Food and Drug Administration. Other health concerns covered by the RH law. I believe we can all agree that teenage pregnancies deprive a young girl of her right to a full life, including opportunity to study and to find gainful employment later on. In Fabella Hospital alone, 2,126 teenagers gave birth in 2010. This figure increased to 2,532 the next year. In Vicente Soto Medical Center, there are teenagers who have given birth to 5, 6, and 7 children. These are teenagers, children aged 13 to 19. They are supposed to be playing with their friends, studying in school, enjoying their childhood, not being responsible for their own children. But that is the sad reality in our country. In the case of HIV/AIDS, the incident is dropping everywhere around the world, but sadly not in our country. We are one in 9 countries with an increasing incident of HIV/AIDS. At present, we have a reported number of 21,837 cases of people living with HIV/AIDS. To conclude, in the guise of protecting the unborn and shielding women from the ills of contraceptives, petitioner oversteps their bounds and transgress the rights of women enshrined in the Constitution. In the case of Civil Liberty Union versus Executive Secretary, this court ruled that no one provision is to be separated from all the others, that all the provisions bearing upon a particular subject are to be brought into view and to be so interpreted as to effectuate the greater purpose of the instrument. Madam Chief Justice, Honorable Justices, this is our reality. 15 mothers die every day. 12 women die from cervical cancer every day. Teenage pregnancies are on the rise. Over 200,000 teen pregnancies in the year 2010. Of the 3.1 million pregnancies a year, 1.4 million pregnancies are unplanned. And nearly 500,000 abortions occur in the Philippines. 10 years ago, there was a new case of HIV every 3 days. Now, a Filipino gets HIV every 2 hours. Contraceptives are readily available for the rich, but are effectively withheld from the majority of Filipinos due to poverty. A clear case of unequal rights of the rich and the poor, and a patent example of social inequity. Case in point, in the city of Manila, former Mayor Lito Atienza declared that only natural family planning methods would be adopted and promoted by the city. This is a clear violation of a woman's right to choose, but for the lack of a law, this situation remained during that time. The RH law seeks to bridge this gap by giving the poor what was once exclusively for the rich, a choice. Honorable Justices, to deprive women of access to family planning, which petitioner wants you to do, violates so many provisions of the Constitution. The right to health, Article 2, Section 15, and the state's obligation to adopt an integrated and comprehensive approach to health development and other social services available at affordable cost, Article 13, Section 11, and the duty of the state to protect the life of the mother, Article 2, Section 12, just to name a few. Madam Chief Justice, Honorable Justices, we held 7 hearings over the span of 1 year. Thereafter, defended it for another year and a half. 11 senators interpellated me. 8 made amendments. 72 amendments were proposed. 54 were accepted. 13 were put to a vote. A similar process was observed in the House of Representatives. Thereafter, we had a bicameral conference. Each provision was passed upon and debated. This law before us today is truly a product of our democratic process. This is the legislative process in its full glory, as envisioned in the Constitution. This is a product of Congress' collective wisdom. This piece of legislation will not solve all the health problems in our country as petitioners appear to expect from us. In fact, it will not save every mother's life or totally eliminate teen pregnancies and abortion. But it will. Yes, I am certain it will address these problems. It will save lives and give Filipinos, especially the poor women, the means to protect themselves and plan their families. We earnestly beseech this honorable court to rule in favor of the constitutionality of the reproductive health law. Thank you, Your Honors.
Justice Abad.
I think we can sympathize with the mothers who suffer and who suffer because of poverty. I think that's something that nobody really will be happy about. But let me ask you, you say that 5,000 women have maternal death yearly.
Well,
about 5,000.
Your Honor, that is based on the average of 15 a day.
Yeah, that's
so
right.
Times 360 days. It's about 5,400, I believe.
Well, is pregnancy a disease?
Your Honor, as I mentioned...
Please answer the question. Is pregnancy a disease?
I am answering, Your Honor. As I said in my speech, it is not a disease, but it is a special condition that requires medical attention.
Yeah, well, because I have here the maternal mortality main cause in the Philippines for 2009. And the cause of death is not directly on about because of pregnancy, because as you said, pregnancy is a disease, but it can bring about some problems. Complications related to pregnancy occurring in the course of labor, delivery, and puerperium. That's the number one cause, 655 deaths out of 1,599. Then, second, hypertension, complicating pregnancy, childbirth, and puerperium, 513. Postpartum hemorrhage, 286. These are all difficulties that our parents, our mothers, or all mothers have to face when they are pregnant. And these are illnesses, these are complications that could be attended to, and lives could have been saved if these poor women had places to go, where they can be attended by competent doctors, with proper facilities, with blood. I think that's many of them die because there's no blood available or there are no doctors available. So, but your solution is to solve this problem of deaths of 5,000 a year. We will put on IUD or hormonal contraceptives about 23 million Filipinos, or childbearing mothers. And according to the World Health Organization, hormonal contraceptives, the one of them, has the highest possibility for cancer. Class 1, no? The highest possibility. Before they said it was merely possible, but based on the finding of the WHO, it is already a reality that it can cause cancer. I can see the suffering there, but I've seen my sister-in-law and my own wife, my first wife, died of cancer. You can see the horror of cancer. And these women are poor. They'll be defenseless against this kind of disease. This is your answer for 5,000 deaths in the Philippines. I do not see how you can balance that the risk to which we will put our people as against 5,000 that could have been saved by proper hospital facilities.
I would be happy to answer, Your Honor.
Please.
First of all, the reproductive health law does not address maternal health alone. As I mentioned in my speech on the other concerns, there are issues like teen pregnancy, there are issues like sexually transmitted infections, there are other reproductive health related issues such as cervical cancer. All of these things will be addressed by the reproductive health law. So although it is true that you often hear of mothers dying as a primary concern of the reproductive health law, that is not the only concern. Having said that, the solution, as His Honor had mentioned, which is to provide IUDs to 23 million women, is absolutely false, with all due respect. The solution the solution is quite broad. One is to provide reproductive health education. This is through age-appropriate education through the youth, and we go up to the women as it is necessary and the couples. And then there is access to services, as
Those
His Honor
solutions are not
mentioned.
objectionable. We are
Yes,
not objectionable.
I will continue to explain, and His Honor can tell me which is objectionable. As His Honor mentioned, the access to services would include the access to health professionals like doctors, and there doesn't seem to be any issue there. But what the issue is, Your Honor, as the example I gave of one of the women who died, she did have access to a doctor who told her that it would be very risky for her to become pregnant again because of her hypertension. Many women are similarly situated, either because of pre-existing medical conditions or just for personal reasons. They are not mentally prepared to have another child. They want to further their education, to uplift their families from poverty, and do not want to have another child. That is where the access to reproductive health products come in. That is where the ability of a family to plan for what is best for their family comes in. A doctor cannot come in and say, mag-condom ka, mag-IUD ka, magpaligate ka. No, that is a decision that only a family, a couple, have to make for their own. So no services can take the place of the need and the access to contraceptives when a family needs to plan for various health reasons or other reasons they may have. Now, to further answer His Honor's concerns, His Honor said that, on giving away IUDs and contraceptives, that is absolutely false. What will be available are a wide range, and that is very clear in the law. In fact, the law says public health facilities must provide a wide range of reproductive health products so that people can choose. That is the objective. And so definitely there is not one type that will be picked. And over again, we accepted the amendments of those against the reproductive health law. We kept on inserting access to family planning. Paulit-ulit po. In fact, if you ask me, the law is not perfectly written because it is interjected so many times with provisions that have already been stated. But to accommodate the concerns of everyone, we allowed it. Now, on the issue that contraceptives have been classified as the highest potential of causing cancer, Your Honor, the Class 1 classification is actually the lowest. The classification of the contraceptive as possibly cancer-causing is put in the same level as microwaves, television sets, and cell phones, Your Honor. So that is the classification. And it is not a final judgment. It is just saying that these are products that may have the potential, just to put things in perspective. And as to the risk of oral contraceptives, let me say that the risk of using hormonal contraceptives is much lower than the risk of dying from childbirth. That is a scientific fact.
Well, okay, I go to another point. Although that's your... Well, you mentioned teenage pregnancy is one of the things that this
Yes,
thing
Your
is
Honor.
going to solve. Because if there had been...
Address, Your Honor, not solve.
If there had been... If teenagers had known that they can use contraceptives, possibly this would then have happened or things like that.
Well, Your Honor, that would be like saying we shouldn't have a seatbelt law, because with a seatbelt law, it is like telling everybody drive fast. It is like saying do not provide for life vest, because it is like telling everybody jump into the water and drown yourself because you have a life
What I'm
vest.
concerned with the payback for that, I see. The payback for that is what we see in the Western world. Well, teenagers or from the grade of 10 in Germany, you know, from that grade, I think even the age of 5, they are already taught these things. And eventually, that is the solution to, you can have sex and not be pregnant. You tell our teenagers, you know.
There is nothing in the law, Your Honor, and we have consulted with the Department.
But you mentioned that this is a solution.
No, what did I mention, Your Honor?
No, you said that we need this law to save teenager from who have a future from
Teen pregnancy.
Yes, so
Your
they
Honor.
can have sex without
That is
pregnancy.
that is the statement which I take exception to, Your Honor. We never said in this law, and if you look into the records, and if you look
Well,
at
how
any...
will this resolve teenage pregnancy if there can be sex with pregnancy? I think that's your purpose. The teenagers should have sex.
As
Those
we
in
speak,
schools should have sex without getting pregnant.
As we speak, Your Honor, without the reproductive health law, 200,000 recorded teen pregnancies in the last year. And every year it is the same. And it is increasing in this country because we consider it taboo to talk about sex. So it is not the presence of reproductive health education that has promoted teen pregnancy. It is actually the absence.
Teenagers don't know that they'll get pregnant if they have sex.
It depends on who the
I don't
teenager.
know.
It depends
I
on who
think
the teenager is. My teenagers know, Your Honor, because I am
Teenagers
very.
should know that if they have sex, they will get pregnant. But what we're going to tell them, you have sex, but don't get pregnant by using these contraceptives.
I do not believe that any responsible Filipino counselor or doctor would make those kind of statements. Your Honor is correct that maybe in some other countries that is how they would put it based on their customs. You want to have sex, do this. In the Philippines, I don't believe it would be ever couched in that way because our customs dictate that we will always veer in the side of abstinence, in the side of prevention, in delayed sex, and the surveys show that as we speak, without reproductive health law, sex is happening all over our country, and they get their information.
But
it is what I'm saying, Your Honor, and it is based on evidence.
Let me read from about even 10 years old. It's already obsolete. Maybe there will be improved educational materials, but this is the materials that they are going to, from my reading, from what they are using. Is too much sex physically harmful? That will be taught in the school. No, because there's no such thing as too much sex. Generally speaking, under normal circumstances, sexual intercourse and masturbation are self-limiting. When one has had enough, this level varies from person to person. One will stop. Okay. So, as he believed by many, however, a virgin woman simply means that her vagina has never been penetrated by the penis of a man. Virginity to many is determined by the hymen being intact, as evidenced by slight bleeding during the first sexual intercourse. Thus, if the woman does not bleed the first time her vagina is penetrated by the penis, what follows is the man's allegation that she is no longer a virgin. And there are many others here. No? So, the lesson really is to say to these kids that there's nothing wrong about sex, provided that you don't get pregnant. And I don't think that is that those are the values we want to place in the hearts of our children.
Well, I agree with His Honor. I do not believe that those statements are age appropriate for different ages. Definitely, I will talk about virginity with a 17-year-old. I will not talk about virginity with a 7-year-old. So what is vital in the law?
But the problem is you're not the one to make this. And you know, if you enroll in a public school, that's what the law says. You know? If you enroll in the public school, even if you're Catholic, you have to attend this class. It's only in private school that it is not compulsory.
Your Honor, I would be very happy to share with this court a situation which is actually what moved me to insist on age-appropriate reproductive health education. I became aware that one of the problems we have, because we have many women who are OFWs, are fathers who are left behind with their children, and we now have a term that is officially recognized. It is called substitute spouse, where the oldest daughter does not only take over the role of the mother as a caregiver of her younger siblings, but also takes over the role of the mother as the spouse. Well, and this, Your Honor, if I may just continue, this is what reminded me that it is so important that we teach our young children that they have a right to protect their own bodies. That just because it is a father, an uncle, or somebody who lives in your own home, they cannot touch you. They cannot touch your private parts. And if you look carefully at Section 14 of the law, we make it very clear that these are the kinds of educational materials we want our children to have access to so they can protect themselves.
I think the petitioners don't quarrel with you. I myself, I think we should have children should learn in early age about these things. You know? In the old times, the idea was don't talk about it. But I think what we need to train are the parents to be able to teach their children these things, but in the atmosphere of a home.
That is true, Your Honor, but what about the instance where I mentioned, where the woman, and we have 10 million Filipinos who live abroad.
No, if you enroll your children in a public school, you cannot absent yourself from this class. And who is going to teach this?
It will be taught, Your Honor.
Outside. I thought it's a family decision, no? But you'll bring in information that may not be within the values of that family. And compelling, actually. Compelling the members of that family to attend this lecture, not under parental guidance, but for strangers. Strangers to teach my children and my grandchildren the matter of sex. Sex without love. Sex without the values that our families keep.
With all due respect, Your Honor, that is a very limiting view of the law. That is not the intention. Every well-meaning Filipino will want to teach children reproductive health.
The materials being used in school.
Your Honor, those are not the accredited materials of the Department of Health. We must trust that our government agencies will be performing their duties in accordance with the law. We cannot assume that Congress is malicious or that the Department of Education is malicious. As we speak, a priest is the head of the Department of Education.
We trust them that pill that I read the other time that says it works as an abortive agent. Sabi na nakalagay doon. This can cause prevention of implantation of the fertilizer. The FDA allows that. No? If we believe everything that all of these things,
we go by scientific evidence, Your Honor.
We trust that the government will do what is right. That's correct. But at the same time, because of the dangerous nature of this law, in a way, then we should have the things we are looking for that will protect also our children. We want our children to know to have sex education. But I think we should train parents to teach children how to do it. And then do it in the company, in the loving company of parents sharing the values that sex is good. Sex makes you happy. Sex is the beginning of another family if you want to have a family. But not sex for sex sake. Ano? Sabi nila sa akin, dyan daw sa sex mate ang tawag niya. You can have a sex mate. Kasi nga, sex is cheap. When we do all these things, sex becomes cheap. We want this thing, but we have to pay for it in a grievous way. That's what I understand.
Well, I would like to put on record, Your Honor, that Congress agrees with His Honor that we do not want our our children to be fed values that are not consistent with our own. And that is the intention of the reproductive health law, that these are trained individuals who will be teaching our children and who are conscious of Filipino values and traditions.
I read from your comment. I think you read your comment.
Of course, Your Honor.
It was, although you say it's
I did not
part of your
prepare
speech,
it, Your Honor, but
so
I did
part
read
of
it.
Speech, you say, I'll ask you about something that is not part of your talk. But here, it's from your comment. You said that the RH law is consistent with the right to privacy, sometimes called the right to be let alone. I think Attorney Roque there, I don't know if he left already, knows very well about it. Since the law gives people, especially women, access to information they need. Is that correct?
Yes, Your Honor.
And the opportunity, it gives the women the opportunity to decide by themselves the number and spacing of their children, correct?
Yes, Your Honor.
Do I take it that without the RH law, women are being denied access to all relevant information about planning the number and spacing of their children?
Yes, Your Honor. Without the RH law, that is what happened. And I cited the example of the city of Manila,
Are
Your Honor.
our women denied access information outside their homes?
They are denied access in information
Outside their homes. Are they denied?
outside their homes?
Yes. They can go out and get the
No,
information.
they cannot, Your Honor.
They are not.
The poor do not have access.
They are not Are our women prevented by force or intimidation from attending secular seminars?
Yes.
They
Yes,
are?
Your Honor. In the city of Manila, they are threatened that they cannot receive they will not be given, and they are humiliated by even having to ask. The women are actually outside the Supreme
Well, I thought
Court
we
and
respect
petitioning.
religious...
Precisely, Your Honor. It is.
So what's wrong with that? If their faith, they say that's bad for our faith, and
Perhaps
you will be committing sin. You have to confess, and then before you get. What's wrong with that?
No, there is nothing wrong, Your Honor, with a church espousing whatever
so you call
religious
that
views they have.
intimidation or coercion?
Your Honor, I call it intimidation if it is the one intimidating is the state, and it happens in certain LGUs, including the city of Manila, where women were not allowed and were embarrassed to even ask for the access to reproductive health. And in the own barangay where I live in, Ayala Alabang, a very prestigious barangay, there was an attempt to have a barangay ordinance, which was of the same nature. And if not for the likes of Secretary Cabral, Lea Salonga, who literally were rallying in front of the gates every day and petitioning the barangay captain to unilaterally.
I don't know if that will be intimidation, because not so many people go to church, really, I must admit. In a number of Catholics are.
Justice Abad, just allow me. May I please ask you to please discipline the audience, especially in the back portion. I do not want any distraction to the justices listening to the arguments coming from the audience, please.
So, are our women prevented from listening to the radio?
Listening to the radio?
Yeah, listening to the
Your
radio.
Honor.
Are our women, or from seeing movies? No?
Of course not, Your Honor.
Or from watching television shows?
Of course not, Your Honor.
Or from receiving phone calls or text messages?
I believe they are allowed,
Or
Your
from
Honor.
reading secular books, newspapers and magazines?
Yes, Your Honor.
Or from doing IGM? Do you know what IGM means?
Instagram.
I-Google mo. No?
I-Google
If you
mo.
need any kind of information, i-Google mo. So
Depende po kung may
are our
computer
women
po
prevented
sila.
from IGM?
Because many poor women, and we are talking of 2.5 million women in the fifth poorest quintile, do not have access to IGM. They may have access to the radio, but we are not certain. In fact, without this law, there has not been a very strong, consistent program. I do not hear much about information on reproductive health on the radio, Your Honor.
You will be surprised though how many people, our people are on internet. It's
No,
not
I do
really
know,
for the
Your
rich
Honor,
only.
but Your Honor, for women with 8 children, half of whom cannot eat in the morning, half of whom cannot eat at night, they do not have time to
Yes, but
IGM.
they have radio, they have neighbors. What I mean to say
Not if you live in a
is
Cariton,
that-
Your Honor.
is that we are not so backward that this law can claim that it is what our women need to give them access to information relevant to reproductive health. If they want information, there are many places to get information. They are not prevented from doing
I
it.
disagree, Your Honor, with all due respect. His Honor was one of those of the justices who questioned, how will you disseminate this kind of information? You will not hear on the radio somebody asking you the questions to find out if you have a health risk and if you can use an oral contraceptive, or whether if you are smoking, or if you have pelvic bleeding or inflammation, that oral contraceptive is not best for you. You will not hear that on your radio, Your Honor. You need to speak to a health professional, and you need to weigh the kinds of contraceptives based on your lifestyle.
Who will not tell you incorrect information according to this law?
Well, Your Honor,
Not all the sides, or only one side.
we will assume that they will do their job, but definitely a better job than a radio commentator, Your Honor. And must hasten to add that not only is it access to information, but it is access to the products as well. Because for the very poor, the government intends to make this available to them for free.
Well, I'm pointing out that even the poor, if we want to reach them out to them and teach them health reproduction, I don't think there should be any objection to that. I don't think so. The real objection here is really about the products and supplies that the government teach them and tell them, under the law, this is safe. Under the law, this is not abortive patient. When that is not so. When it is not really safe in the sense of, as we understand safe. Safe is free from danger. But we all know that contraceptives, intrauterine as well as drugs or medicine, they are not safe.
In that case, all medicines will be declared not safe as well, Your
let me go to
Honor.
another point. But most children in public schools are Catholics, correct?
Well, our population is mostly Catholic, so I will assume
most
that
of them
includes
in
the
public
children.
schools are Catholic. But the government, claiming the right to teach what it wants in public school, would have all children in these schools learn how to use contraceptives, among other
That
things,
is
correct?
incorrect, Your Honor. That is incorrect. There is nothing in the
they will
law.
not be taught this in
There is
school.
nothing in the law that says that children will be taught how to use contraceptives. The
No,
law
it says there,
It does
all
not,
the
Your Honor.
methods will be made available in the schools. They will be taught all the full range of
There is nothing.
methods.
I would be happy to see what part of the law His Honor read that, because that is not in the law, Your Honor. What is in the law is age-appropriate reproductive health education. And it may not be age-appropriate to talk to 5-year-old or 10-year-olds about the use of contraceptives. In fact, it is not age-appropriate.
Well, what will be age appropriate?
Well, I would be happy to explain, Your Honor. For example, I have been pregnant 4 times, and as my toddler would see my bulging stomach, I give her an age-appropriate lesson by saying that there is a baby growing in mommy's stomach, as opposed to what others who are not comfortable talking about reproductive health, they will say, may lobo, o nakakain ng pakwan, si nanay, o ang kapatid mo lalabas sa bungang kahoy. So age-appropriate reproductive health education will vary as the child gets older.
But this is sex education, is that?
We are talking about reproductive health, which is broader than sex education, Your Honor.
Yes, sex education, that's what I'm saying. So whatever the age is, it will be about sex education.
No, Your Honor, reproductive health is not equal to sex education. Those are entirely different things. So
reproductive health is about reproduction, and reproduction is about sex. I don't know what...
part of it is, Your Honor. This is a science, Your Honor, and they're very precise with the use of their terms.
That will be an incomplete education. Why will we still have sex education in schools if we will not teach sex? what's the use of this law?
Precisely, Your Honor, the law teaches
So
reproductive...
this is not about sex education.
It is about part of it is about
Oh, that's what
reproductive
I mean.
health
So-
education. No, Your Honor, I am not changing what I am saying.
Well, I know.
It is about
There are nice
reproductive health
things here that will
education,
be taught to
not
children.
sex education.
But I'm
His Honor
focusing-
is of the view, if I may, I believe His Honor is of the view that when we refer to reproductive health education, we're talking about the sexual act alone and the use of contraceptives. That is a very limiting view of reproductive
because the
health.
other things
That
are no
is
problem.
a component only.
The other things, the other aspects of this reproductive health, I don't think anybody really object to them. Like they should clean themselves. They should watch out for certain signs. These are good things. Nobody's against that. But what we are teaching here is sex education, how to avoid pregnancy. This is all what it's about.
And also, Your
how
Honor...
to space the number of children, how to fix the number of children you want to have, and to space them. And that's what's that about?
Your
That's
Honor...
about controlling birth. And I think you're trying to
That is one aspect, Your Honor.
to cover the whole thing with a lot of good things. But no, we have nothing against the good things.
Well,
what we are against the bad things.
Well, I don't know, because some people would consider it bad if you try to tell a child that her private parts, and I will use the proper terms, the vagina and the penis are private parts that neither your father should touch
those are
or
not bad
No, Your
parts.
Honor, allow me to continue because this goes into sensitive topics that we do not like to discuss. And these are subject matters that we want to be made available so that our children can protect themselves. How can you say
But
to
at
let
any
the
rate, in these
if I may
public
just finish
schools-
my statement, Your
I'm
Honor.
going to another point. In these public schools, the law would not even require parents who value the inculcation of their faith to their children to give prior written consent for them to attend the sex education in school. They're not required to have consent from parents.
That is not in the law, Your Honor. But
That's
that does not
Well,
prevent.
if it's not in
But
the
that
law,
does not prevent
there's
the
no
department.
consent needed. Okay.
No, it does
The
not prevent the
government-
Department of Education
well,
of coming
so
up with a
it's not in the law.
memorandum
That's why nga-
to that effect, Your Honor.
Compulsory if it's not in the law because it's part of the curriculum. Nakalagay po dyan eh. The government can compel all public school students to learn sex education as it sees how it should be learned. Of course, with consultation with parents, teachers, etc. Except the parents themselves.
No,
It's not there.
Your Honor, the law is very clear with parent, teacher, community, association,
But not
school
with the
official,
parents of the
and
children.
well, then the parents can attend, Your Honor. And Your Honor, if I may go back,
You can
to
come and
the-
say, I'll meet you today, we will discuss about it first, and then teach the children together or something like that. But not there here. No? This one is purely government approved.
with the consent of the
Education.
community and the parents association. Your Honor, I will bring back the example of many children who are abused. How do you expect the mother who is out of the country and the father who abused his own child to be the one to give the consent? That is why the state must come in and protect these children.
Then you should,
That is why
you should
the
provide
state...
for something for that, for special circumstances like that.
But Your Honor,
Those are,
then that does not
anecdotal,
make then I've proven my point, Your Honor. It does not make the law unconstitutional.
But the law does not
Just because the law does not specify that one particular situation does not mean that the intention, which is clearly written in the law, is unconstitutional.
The law must state what these protections are. Because otherwise, as I said, the law can be abused. Now, would the law allow a physician who has a bias against artificial contraceptives on account of his religious beliefs to advise a patient who shares the same belief against the evil of such contraceptives?
Your Honor, to me that is a very simple question. Every literature for every medicine and contraceptive provides the side effects and the ill effects. So all the doctor has to say is, these are the possible consequences. If you are a smoker, if you are above the age of 35, or if you are a teenager, your risks are higher. And if you will if you drink alcohol, if you will be indulging in risky sexual behavior, then these are the consequences. All of that is clear. There is nothing wrong with a doctor discussing that with any patient, whether or not they share the same belief or not.
I'm glad you say that now. when the state teaches sex education, see, but it's not sex an area where immorality can easily take hold, as in prostitution, women trafficking, pedophilia, not to mention promiscuity. Sex is an area where morals are involved. Don't you think so?
Morals are involved
Sex
in
is
many
nothing to do
aspects
with
of
morality.
our life. Morals are involved in many aspects of our life, sex and many other things.
Sex has no
I said
moral implication.
No, I said morality is
Yes, morality.
involved in many aspects of our life, not just in sex.
So, will you agree that? So, is your position that in sex education, morality is not involved?
It can be discussed, like when you discuss age-appropriate reproductive
You did not
health.
answer the question.
No, I am answering, Your Honor.
What's your answer?
Because reproductive health education always has to be age-appropriate. So when I talk about a baby growing in my stomach, there's really no sex involved there, and that is reproductive health education. When I tell a teenager that please do not get involved in sexual activities with that boy who is courting you, because this may lead to pregnancy, this may lead to... I can say it in a scientific way and in fact, and not in any way touch on moral issues. I can also say it in a way that will tell them that they will be condemned and go to hell.
You're not
So there are
answering my
many
question.
ways.
My question is not sex an area that has a moral concern?
It depends on the topic.
You agree?
It depends. I agree to a certain extent, not always. As I said, I can discuss sex and reproductive health in a manner that has no moral function. Like when I explain how a baby grows.
So that is the position of the state here in this law.
What's your
That
honor?
sex is not a matter of moral concern. It parang relativity, it depends, but it is not part.
It depends, Your Honor. If we're talking about your
That's
right
what
not
you
to
say,
be sexually abused, that is...
It depends. I think that's a policy that... but you see, the Constitution says that the natural and primary right and duty of parents in the rearing of the youth for civic efficiency and the development of moral character shall receive the support of the government. So parents have, under the Constitution, the natural and primary right and duty to educate their children for the development of moral character. Can the government compete with parents in the molding of the character of their children?
Is it a competition, Your Honor?
Can the government compete with parents in the molding of the moral character of their children under this provision of the Constitution?
I am not aware, Your Honor, that the government is in competition with the family. Consistent with the Constitution, the intention of this law is to support...
Well, the government excludes the parents from the seminars where their young children, 5 years and older, are going to attend. You're out of this. This is what the law says.
No, Your Honor, the law includes every parent may attend. There's nothing that prevents a parent from attending.
Should not the government respect the primacy of the right? It is more in keeping with this right of parents for the government to secure consent in the matter of sex education of their children in public schools. Should not they get at least consent of the parents in the matter of this?
Congress has decided that is not required, Your Honor.
You assail petitioners for advocating only natural methods and not the modern methods, but as I said...
No, we assail petitioner for demanding that the state only promotes natural family planning. They can promote whatever they want, but they cannot demand that the state promotes only natural family planning. That is what we assail, Your Honor.
But it's not on that ground that I find some difficulties, although I've not yet made up my mind. But it's not on that ground that I find some difficulties. It's in the heart of the law that makes hormonal contraceptives and intrauterine devices declared as safe and non-abortive patient, and to be included in the essential drugs list, bypassing the FDA. I know they're saying it's subject to FDA, because ordinarily, medicines cannot be given to the public or put in that list unless it is approved by the FDA. But this law, it says, I command you to put these contraceptives, hormonal contraceptives, and intrauterine devices in the essential drugs. So it orders a bypassing of the FDA. Anong iniwan niyang function sa FDA? The FDA, sabi niya ron, the same Section 9, will issue a certification that none of those who use these medicines will use it as abortive patient. That's the role that the Section 9 reserved to the FDA. And also, yung preparation of the guidelines for safe use, but not for non-use, only for possible use in the face of side effects and harmful effects. That's the rule. I read the whole law. I did not find there any provision that says that in this new one, because let's face it, contraceptives is not medicine. It is not, unless, well, there are some of them that will be intended as medicine. Medicine is to cure illness. This is a new thing that will be put in this official drugs list. You see? And it is not medicine because it is not intended for cure. The benefit that will be obtained there is not being healed of heart attack or any difficulties or serious problem, but to be able to have sex without responsibility. That is the exchange. You cannot treat this like medicine where we can ignore the side effects because we will save human life. No, this one, no. You will ignore the side effects so you can have sex without having to answer for it.
Your Honor, I would be happy to respond.
That's what it says. That's what it is about.
With all due respect, Your Honor, your understanding of the law is incorrect. Section 9 very clearly includes other safe, legal, and non-abortive fashion devices. So, Your Honor, this modifies the enumeration of hormonal contraceptive, intrauterine devices, and injectables. As I explained, Your Honor, these products have been available in the National Drug Formulary even before the reproductive health law was discussed. So we simply institutionalized the practice. I would like to explain to this court so they understand the nature of this provision. The intention was to prevent the National Drug Formulary from taking away contraceptives as part of the essential drug list.
Well, that's different from the answer of Congressman.
It is the same. Actually, I may not just be explaining
Lagman,
it as
that's
well
different.
as him. No, we have
Also,
the same
OSD
explanation, Your Honor,
answer.
that it was our intention to ensure that these products, as a type of products which have already been recognized by WHO and FDA as safe, continue to be in the National Drug Formulary. But it does not in any way take away the duty of FDA to rule on the safety, efficacy, or abortive fashion nature of not new ones, Your Honor. Your Honor, there may be a misunderstanding on the use of the general term of intrauterine device, hormonal contraceptives, or IUDs. There are many kinds. So what we are saying in this law is these types of contraceptives have been passed upon by the WHO and FDA and are part of the WHO essential list and have been part of the FDA essential list. And we want it to stay there subject to FDI's determination per brand, per batch if necessary, that it is safe. We cannot take that away from FDA. We never intended to arrogate these powers. These belong to FDA's alone, not ours and not this court's.
Section 9 does not refer to types, or Section 9 refers to products and supplies.
Your Honor, these are general terms. That's what I'm trying to say.
Outside the realm of idea, but in the realm of commercial products and supplies, that is being, legislated as into the National Drugs Formulary or the Essential Drugs List. It bypasses
It does not. With all due respect, Your Honor, it does not. And both the members of the lower house and the upper house tell this honorable
That's
court
what confuses me,
that
because
is not,
you have a different version, Congressman Lagman. From my point of view, as I look at it,
then
and the Solicitor General-
I apologize for not explaining
not
it as
bound
well
by-
as Congressman Lagman, but we do have the same point
We
of
cannot
view,
have
that we are
different
not
views
trying
as to
to
what it is.
bypass the FDA.
We should understand it as what the law, the language of the law says.
And we do understand it. We do understand it, and we are trying to impart to this court the clear intention, and to our mind, what is written very clearly in the law. Include hormonal contraceptives, intrauterine devices, injectables, and other safe, legal, non-abortive fashion and effective family planning products. In other words, if the hormonal contraceptive was not safe, if it was not legal, if it was abortive fashion, then it should not be included. So it was very simple to us, Your Honor, when this was being discussed, that was the clear
Thank
objective
you,
of the
Madam
law.
Chief Justice.
Justice Leonen.
Because I was barely able to make out some of your explanation, can I ask?
Of course, Your Honor.
Can I ask a bit of clarification? The proposition that the RH law is to encourage sex, would you say that this is correct?
No, Your Honor, it is entirely false. It is farthest from the truth from the framers of from the legislators who made this. The intention of this law on that aspect, on the aspect of sex, is to make the information available to those who need it, either age appropriately because they are minors, or for women and couples to use the information to the extent that they need it in planning their family. There is no intention to change the beliefs of Filipinos, to make children or teens, or for that matter, young adults, promiscuous in any way. In fact, I think media and society does a good job of doing that already. If at all, this will make teenagers and the youth more responsible because they know the effects of their actions. Your Honor, I mentioned in one hospital alone 2,000 teen pregnancies. 2,000 teen pregnancies, and asked them in a very popular show. They featured a young girl who wanted to commit suicide because she thought that she could get pregnant from kissing. She was going to commit suicide. And there is the opposite example that I can give. There are teenagers who have sex who had no knowledge that that act was already a violation of their person and also could make them pregnant.
The next proposition is teaching students sex makes them promiscuous. Is this something that is also a premise of this law?
Definitely not, Your Honor, and let me just add that that is always the position put forth by some groups who do not believe in any way in educating children about reproductive health, and it is the belief of Congress that it is only through education that you can prepare our children to be responsible adults.
That teaching them sex can make them more responsible about the sexual act. Can that be possible?
Well, let me just clarify the statement, Your Honor. Not when His Honor says teaching sex, I would phrase it a different way. Teaching reproductive health education, because teaching sex may give the connotation that teaching the sexual act. Again, it would depend on the age. And we leave that to the Department of Education to determine that.
And there is something about sex as a reality which causes a lot of passion among human beings. But maybe just as a to lay the basis for my question relating to that, is it possible to use physics for immoral things, such as, for instance, to create a bomb or to calculate the trajectory of a mortar?
So His Honor's question is there a moral issue?
Yes. Is it possible to use physics for bad ends, such as, for instance...
Well, yes. If you're going to create a bomb and wipe out a particular religious group or a particular sector of society.
As a matter of fact, my property law professor also demonstrated that it's possible to use property law for devious things, is it not?
Yes, Your Honor.
For that matter. In fact, there is even the theory of the bad man by Oliver Wendell Holmes. Is that not correct?
Yes, Your Honor.
Yes. So sex can be used for in an improper way or for immoral ends. Is that not correct?
It can be used in many ways, Your Honor, including improper and immoral ends, as I was saying earlier.
But it is an inherent human function. Is it not correct?
It is, Your Honor. We
And,
would not be here if not for sex.
And there are many theories about what you do with sex. For some, it is for procreation.
Yes.
For some, it is shall we say, a celebration of one's intimacy with another person.
Yes, Your Honor.
For others, it is recreation.
Yes, Your Honor.
Can we not accept that?
We accept that, Your Honor.
Can the state dictate what sex is for?
No, Your Honor. And that is why this law needs to be able to be applicable to any person with any belief that they have.
In your experience as a representative of our people having been voted into the Senate, can you tell us why many in our population say that whenever you talk about sex, it is bad? Why is that so?
I believe, Your Honor, it's because we do consider ourselves a conservative society, and we are, they say, 90% Catholic, and the Catholic religion teaches abstinence and sex only during marriage. And so for that reason, any indication of any sexual activity outside of those boundaries are considered immoral by a portion of our society, but not by others. And therefore, that in itself creates the conflict of understanding and views on how to come about with a policy that will be applicable to all.
If a dominant majority of the sovereign Filipino people are Catholic, why is it that we just don't adopt, or why can't we not just adopt the morality of Catholicism into our law?
Well, that is precisely why our Constitution has the freedom of religion clause, Your Honor. It's as simple as that. When I gave my sponsorship speech, I said I would stand up for the right of every Catholic, even if there was just one Catholic. And I will stand up for the right of one person of any religion to exercise their freedoms. And this is what that is all about. That one religion cannot dictate what this law is about.
And for the mothers that you've shown on the PowerPoint presentation a while ago, this discussion that we're having right now is abstract. Is that not correct? That for them, sex is something that they do with their husbands because their husbands demand it, but they have no theoretical or moral idea of why sex is bad or sex is good. Is that not correct?
Well, sex is just part of the relationship with their husband. And if I may add a very controversial line, which is in the reproductive health law, that is why we fight for the right of women to safe and satisfying sex. Because that is included in in the women we show here. They cannot have safe and satisfying sex because they want to give in to their husband. How can that be safe if they know they will get pregnant or they might die? How can that be satisfying if they know they are fearful that they will get pregnant with the next encounter they have with their husband? And that is why it is an integral part of reproductive health.
In all probability, the parents of people who cannot afford 3 square meals a day, in all probability, will they be able to get into a private school?
No, Your Honor.
Is it also possible that some of their children, or perhaps they themselves, can get into a public school, like the University of the Philippines?
It is possible.
Given the socialized tuition fee that
Yes,
they
Your
have,
Honor.
that there is subsidy for bracket E, if I'm not mistaken.
Yes, Your Honor.
We are familiar with that
Yes, Your
because
Honor.
we come from that school and you are in the Board of Regents. Is that not correct?
Yes, Your Honor.
Yes. So it is possible that they get to a public school, not a private school. Is that not correct?
It is most likely that they will go to public school. There is always a chance if they have some talent or any other skill that they could get a scholarship in a private school. But their bigger chances to enter a public school.
So the children may get to a public school. The parents of these children, where will they get their sex education from?
The parents.
Yes.
Well, Your Honor, that is a requirement that is now included in the law. It is actually just a repetition of a
Without this
presidential
law,
decree.
would you say that they will get their education on sex from television shows?
That is the question, Your Honor. We have no idea. They could get it from commentaries. They can get it over men drinking beer and getting drunk and talking about raping their child.
And therefore, when we say that we should rely only on the family to be able to teach our children sex, we are not taking as a paradigm the people from your village. We are taking as a paradigm the entire Filipino people. Is that not correct?
Yes, Your Honor, but if I may add, even the people from my village, even my friends, ask me to talk to their children about sex because I am more comfortable as a mother. I don't know why, but I am comfortable talking about it. And so even educated parents have difficult time talking to their children about reproductive health issues. So from across classes, it is a difficult topic, understandably.
You have indeed a very interesting village. But in
Yes.
any case, so what we are saying is that the reproductive health education found in Section 14, is it designed to replace the abilities of those that have knowledge already about sex, are courageous about it, or have some very definite moral framework for it? Is it a substitute for that kind of an education?
Definitely not, Your Honor.
Is it a substitute for the education that we get when we enter a Catholic church?
No, Your Honor. All these educations that we would receive from our families, from our church, from religious organizations would still continue to be there.
Senator, can you point to us the basis in law of what you said, that the parents are going to be involved in terms of the preparation of the curricula and in the determination of the content of the curricula in the law?
Yes, Your Honor. In the bottom half of Section 14, the title of the section is Age and Development Appropriate Reproductive Health Education. It states, provided that flexibility in the formulation and adoption of appropriate course content, scope and methodology in each educational level or group shall be allowed only after consultation with parental teachers, community associations, school officials, and other interest groups. Your Honor, this was actually an amendment made by the anti-RH senators and congressmen to accommodate precisely the concern that His Honor mentioned.
Thank you. A few more questions on another point, and this is on conscientious objection. Can you tell us, Senator, why the qualification in relation to conscientious objectors?
Why, Your Honor, do we allow conscientious objections?
Yes. How it got into the law?
Yes, Your Honor.
That's what I meant.
Your Honor, the primary intention of the reproductive health law, consistent with the Constitution, is to provide health care, and in this case, reproductive health care, which is considered a right of women and of people in general. So, Your Honor, the issue comes up on the use of contraceptives, where some religious groups, in particular the Catholic groups, do not believe in the use of contraceptives. So what happens when the only access to a doctor that you have happens to be a believer of their faith dictates that they cannot use contraceptives, and then they will state that they cannot advise you as such? I give you a case in point, Your Honor. Ligations are usually done in the right after the pregnancy. So I know women who have already concluded that after this baby is born, the third, the fourth, whatever, magpapaligate ako. And then there are cases where they enter a Catholic hospital not knowing that the Catholic hospital and the doctor will not perform ligation, and they lose that opportunity to have that ligation. So that was a specific instance that I could not forget, because I believe that should be information that should be provided to a patient. The hospital and the doctor should declare, if the patient tells them, I do not expect the doctor to read their mind, but if you did go through prenatal care, it is certain that you have discussed this with your doctor. So for your doctor to tell you after you come out of anesthesia that, sorry, we were not able to perform because it is against our religion, to me, violates the right to health of that person.
So in other words, Senator, you're saying that there are two parties involved in this kind of a relationship. One is the doctor or the health worker that
health
is
provider,
involved.
yes.
And the second one is the patient.
The patient, Your Honor.
So when we talk about conscientious objection, we're only talking about the doctor's conscience. Is that not correct?
We are talking about the doctor's conscience, but I guess it would also...
In other words, it is focused on the service provider, the doctor, etc. But there is nothing here in the law, in fact, that says that it is the patient who is actually wanting the treatment or wanting the advice. So there is also a patient here, and there is such a thing as patient rights. Is that not correct?
Yes, Your Honor. Yes.
Conscientious objection is therefore the right of the doctor. However, we have to also take a look at and balance the right of the patient.
Yes, Your Honor. Yes, Your Honor.
And if the patient does not happen to be Catholic, but rather someone who really wants advice on how to space their children and wants a full menu of options. When they go to a conscientious objector and you do not provide for the provision that they can be referred, then the right of that patient will be violated. Is that not correct?
Yes, Your Honor. Precisely, we crafted this law knowing that many women will go to a healthcare provider not knowing what her options are, not knowing the full range of services that are available, that are affordable, that would be personally best for her given her age, given her situation with her husband, given the number of children that she has. So it is two relationships that are come into play here, Your Honor, and we need to protect the right of this patient to that information.
In fact, this is not a strange thing, because this is in the rules of obstetrical and
Yes.
gynecological society. It's a very difficult word, and OB-GYN societies. Maybe that would be that would be easier. And of course, this is in the International Federation of OB-GYNs. That, as a matter of fact, it does provide for priority for patient rights. Is that not correct?
I am familiar with that, Your Honor, and based on those declarations, they are supposed to provide the information.
Would you know, since you were, of course, the principal sponsor in the Senate and you would have conducted a lot of committee hearings, whether the Philippine OB-GYN Society is a member of that international OB-GYN organization with that declaration?
I believe they have a similar declaration, Your Honor, but I have to be transparent about this, that obviously they also have members who are very strong in their Catholic view, and personally they have other views. So I don't know how the society is dealing with that. But as a society, that is the right to health of the patient is paramount.
And as a matter of fact, even the World Medical Association, for which the Philippine Medical Association is a member, also has a similar declaration regarding patients' rights not to be prejudiced by the conscientious objector, who may be the doctor or the health worker. Would
Yes,
I
Your
be
Honor.
correct in saying that?
Yes, Your Honor.
So in the determination of Congress, in weighing the right of the conscientious objector and weighing the right of the patient, you came out with a balance. Is that not correct? And that balance is now found in Section 23, in that subparagraph. Am I correct to say that, Senator?
Yes, Your Honor. I have to say that I personally, along with members of our committee, really took a hard look on that, Your Honor, because I work very closely with the doctors and the Doctors Association, having been the chairman of the Committee on Health for many years. So I was very conscious of how this would affect their rights, of how this would affect the use of the information they have. And we came out with this decision, and it was upheld in both the Senate and the House and in the final version, Your Honor.
At present, would you know how many Catholic doctors would actually avail of that option, being a conscientious objector?
I am guessing, Your Honor, because I did not really conduct a survey, but because I've been invited to speak to so many medical associations, I can tell you by the nature of the reception to me when I speak on RH law, it's a very small percentage of group of doctors who believe strongly that they have the right to conscientious objection.
So it is there, but we are not sure whether more than 50% will use it, whether only 30%, whether 80% will use it.
Well, Your Honor, if I'm not mistaken, I do not recall that we even received any written position paper from any group of doctors that they want to avail of this, because and it's not as if they did not have access to me, because as I said, I've been the chairman of the Committee on Health and have passed so many laws, including the PhilHealth law, the cheaper medicine law, the FDA law. All of them have access to me, so I don't
before
recall.
a doctor actually avails of this, that doctor will have to go through layers of decision. First, the ethical choices that doctor must do. Second would be their professional choices based upon their memberships in these organizations of their profession. And finally, of course, when they've done or made that decision, then they would come to a court of law or probably be hailed to a court of law. And that would mean whether the patient is actually going to file against the doctor. Is that not correct?
Yes, Your Honor.
At this point, if we rule on this provision, are we making a theoretical judgment?
Well, Your Honor, at this point it is premature.
What do you mean premature, counsel?
Well, we don't even have a case in point. We have no situation where you have a doctor who is availing of that right to use their consensus objection. So it is almost like asking this court for declaratory relief, which I don't believe is part of the functions of this honorable court.
And we are assuming, of course, that the doctor and the patient exist in a vacuum.
Yes, Your Honor.
There may be certain circumstances, like for instance, a clinic with a poster. Or for that matter,
Yes.
The patient might not be somebody who does not eat 3 times a day, but somebody who comes from a particular status in life, etc. And therefore, there are many factors,
Possible scenarios.
permutations of facts
Yes.
that we do need to take into consideration. And would you say that the danger is that, again, we will be replacing our own vote with that of the Senate, a majority of the Senate, majority of the House, and carte blanche, totally declare this as unconstitutional without taking into consideration the situations where our objections may apply or our objections may not apply?
Your Honor, in the statement that I made earlier, I mentioned that there were 72 amendments made in the Senate alone. 54 were accepted, 13 were put to a vote. One of this is the conscientious objection. And prior to this, there were 7 hearings that lasted 4-6 hours. So we have discussed this, and we humbly submit that this is a product of the wisdom of the Senate, of Congress, Your Honor.
Only if you would prefer to answer, because I know that this is the topic of Professor Hilbay. This chills. This provision has a chilling effect. It scares doctors. It scares the conscientious objector. Have you considered that in terms of your deliberations in the Senate and in the bicameral committee?
Yes, I would like to answer in line with His Honor's questions. Did we consider it? Yes, we considered it, Your Honor, and precisely why the way we worded the law was knowingly withholding information or restricting the dissemination of, because precisely we know that there is a religious group who would not want to disseminate, who would not want to provide any kind of information on reproductive health that is contrary to their religious views. And we believe that the paramount concern of the state is to provide for the health of these women and these couples who need it. And that is why we needed to put this provision there. But it is not meant to be used maliciously against any doctor. And I think we must assume that in any law.
Maybe one more dimension.
Yes,
before,
Your Honor.
Before I end. Information is different from opinion. Is that not correct?
Yes, Your Honor.
For instance, that you say that people can get pregnant by kissing. That is wrong information. Is that not correct?
Correct, Your Honor.
Are you sure people will not get pregnant by kissing?
If it doesn't accompany any other actions.
Okay. It is a precursor, but it is not necessarily the only cause that's necessary. Is that not correct?
Yes,
Thank
that
you
is
for
correct.
the education. The sex education right now. But on the other hand, when you say this condom is bad,
that is an opinion, Your Honor.
It's an opinion. Can you say this condom, when you use it, you are committing a mortal sin? Is that information?
No,
or
Your
opinion?
Honor. That is not information anymore.
So when a doctor says, you have to go to another physician because my conscience cannot tell you the other technologies that are available for you to space your children, but let me tell you, all of these are evil. Okay? Will that be punishable under the law?
Your Honor, the health provider did what is correct by referring the patient to somebody else. By saying it is evil, I think that is unprofessional and unethical, but I do not believe that it is punishable under the law, because what the law penalizes is knowingly withholding information or restricting the dissemination thereof, and or intentionally providing incorrect information. So to say that this is evil may be questionable,
a bit
Your
of
Honor.
exaggeration, but in order just to drive home that particular point, and perhaps you can cover that also in the memoranda that will be submitted to the court. Just that, of course, that there is that possibility that doctors can say that this particular material is not sanctioned by our beliefs.
Yes, Your Honor, and that is allowed. That is allowed.
So it is not subjected to criminal penalties.
No, Your Honor.
It is not within the concept of any violation of this law.
No, Your Honor. The freedom of expression allows a health provider to state their faith and to make, obviously, that goes beyond their call of duty to lecture the patient, but to just state their faith and say that I cannot provide you with the information because of my views is allowed, Your Honor.
Did you know, Senator, that in about 9 places in the RH law, you mentioned religion?
I'm sure I don't know if it's 9, but I know we repeated it many times.
For for the number of sections in this law, which is about, I'm sorry, let me
29. 30 with the effectivity clause,
yes. The effectivity clause. You mentioned religion 9 times. Why is that the case?
Because, Your Honor, we wanted to be sure that we protect the right of people to their faith, and we make it very clear that we are not imposing any religious view and that everyone is free to practice their faith in the context of the reproductive health law.
Thank you, Senator.
Thank you, Your Honor.
Justice Carpio.
Senator, just one question. You mentioned something that struck me. You mentioned of the eldest daughter being a substitute wife.
Yes, Your Honor.
When the mother is abroad working as an OFW. If you read our cases on incestuous rape, that is exactly the profile. The father raping the daughter while the mother is abroad working. And they live in just one room house.
Yes.
Where they sleep together.
Yes.
And the father sleeps beside the eldest daughter,
yes.
And at night, the rape just happens. Okay. Now, how will the RH bill or RH law address this specific problem?
Yes, Your Honor. Let me have a prefatory statement. The RH law will not solve that problem entirely, definitely. But what it can do is give children the information that they need to know, that their body is private and no one, not even their parents, can touch them. So as soon as a child, because usually, Your Honor, this happens in progression. There is usually just touching, followed by kissing, and then perhaps penetration. Sometimes that happens over a course of years. So in the first sign alone, if a child is knowledgeable enough to know that that was inappropriate, I should not have been touched in that manner by my father or by my uncle or by my brother, because it happens to any family member or close person living within the proximity of the home, then we could prevent this child from being raped or from the rape being consummated. Because from the first act alone, the child would already be aware that there was something inappropriate, and they are taught to tell the teacher or to tell another older person who they trust.
Thank you, Counsel.
Justice De Castro.
I just want to get your opinion.
Yes, Your Honor.
About the other side of the 2 issues that you mentioned earlier. The law defines reproductive health rights to include, among others, the right to attain the highest standard of sexual health and reproductive health. And then the law defines sexual health as the possibility of having pleasurable and safe sexual experiences, which means that you have elevated the ability to have pleasurable and safe sexual experiences. And you said that this is meant to allow women to have a pleasurable sexual experience just like a man by taking contraceptives. Now let us look at the other side of this issue. Assuming that a woman, a wife, refuses to take contraceptives, and because of that, she denies her husband access to her body because she fears pregnancy. Since this is a right, not only of the woman, but also the right of a man, will this now be considered the refusal of the woman to take contraceptives, which denies such right to a man to enjoy a sexual experience with his wife now amount to a ground to annul marriage on ground of psychological incapacity because of the inability of the woman to assume or to assume the responsibilities that is recognized here under this RH law? Or are we moving towards that direction of using this as a means or as a ground to annul marriage?
Actually, Your Honor, even without the reproductive health law, there is the concept and there is a crime defined as marital rape. So without the reproductive health law in the picture, a man cannot force himself upon his wife. So a wife at any time, whether it's because she is fertile and she doesn't want to get pregnant, or because she has a headache, or she had a hard time taking care of her 8 children, has the right to say no to her husband. So it has nothing to do with the reproductive health law, Your Honor.
Think that after the passage of this law, this can be used
No, Your
as
Honor.
a basis?
No, Your
Because
Honor.
you have elevated, the law elevated to a right.
Your Honor, the right has...
Before there was no such right, but now you have elevated to a right.
Actually, Your Honor, we are signatories of international conventions that recognize this right. So all we did was include it in our law so that this international treaty or convention that we are a signatory to is now embodied in our national law. And reproductive health rights, Your Honor, is really considered a human right. So there is nothing really that we as the authors of the law can do, but it does not in any way promote annulment or promote the dysfunction or disunity of the family. Your Honor, if I may, would Her Honor allow me to read a certain portion of the Senate deliberations on this matter? Your Honor, this is actually the statements made by Senator Alan Cayetano when the phrase safe and satisfying sex was being debated. He said, in the past, yung sex life ng mag-asawa ay naapektuhan dahil sa pag-iisip ng mga lalaki. For example, ang paniniwala ng lalaki, hindi pwedeng tumanggi yung babae. Ang paniniwala ng lalaki, kahit kapapanganak pa lamang, o kahit buntis, o kahit mayroon siya, at hindi siya komportable, ay pwede siyang gamitin ng lalaki. And he went on, Your Honor, to explain that precisely the times have changed now, and we now recognize that these are rights of women. So, Your Honor, what we tried to embody in this law is the right of women to their own bodies, such that if their husband wants to have sex with them all the time, and they are going to get pregnant again, they do have that right, Your Honor, to say no to sex. And we are recognizing here that that right is a reproductive health right, which we must honor.
But the law emphasizes pleasurable and safe sexual experience.
Yes, Your Honor.
That is what has been elevated to a right.
Yes, Your Honor. That is absolutely correct.
It's not the protection from refusing to engage in the sexual act with a husband. That is just
Your
I'm
Honor,
just bringing this out as
and
I'm happy.
I am happy. Her Honor is mentioning that. If I may continue to read from the transcripts again from Senator Alan. So my first point, Mr. President, bakit natin ayaw, referring to the term safe and satisfying sex? Why are we uncomfortable? If we are uncomfortable, and if we all desire a safe and fulfilling sex life, is it malaswa per se? Because if it is malaswa per se, then maybe we can find a language that means the same thing. I came from a Catholic school, sa Lasal. Everyone was laughing when they used the word siping. Of course, there are dirtier words to use meaning sex, but it is accepted to Filipinos to use siping because it sounds scientific. It does not sound malaswa. So if we are saying that the English term, again, safe and satisfying sex is malaswa, then let us find another term. But if we are just saying we are uncomfortable because we are more prude and we are more conservative, do we sacrifice the substance of that paragraph just to satisfy being prude? So it is something, Your Honor, that people still fail to understand, that a woman is entitled to safe sex. Safe meaning she will not get pregnant, she will not get a disease. Many women are unconscious of the fact that the men they sleep with, their husbands, bring a disease when they have sex with them. She is entitled to that. Now, if she knows her husband is fooling around, how can she have satisfying sex? How can we deny that? That is a right, Your Honor, and that is a right we recognize.
Well, I just brought that up because you have elevated, this law elevated this to a right. And I have gone through so many international conventions, treaties. I have not found any convention recognizing this as a right. It is only in a soft convention. When I say soft convention, it's not an international agreement in the sense that we understand it. That this right is used. Well,
Your Honor,
my research may not be exhaustive, but please try to see if there is an international
there
agreement
is, Your Honor,
or treaty.
This is the Convention on Population and Development and CEDAW, the Convention on the Elimination Against Discrimination Against Women.
Will you point that out? Because I tried to look for that.
Yes, Your Honor. If we can get it while I am answering, I will be happy.
I just want to find out if we're moving towards the direction of using this as a basis to annul marriages or to go towards the enactment of a law on divorce.
That is not the intention, Your Honor. I can put on record that that was never discussed in any context whatsoever. The only context of which it was used was it the proper language, as Senator Alan had mentioned, and my explanation to about 6 male senators of how important it is for women to have the right to safe and satisfying sex. It is interesting to note that it was men who were questioning why women have that right to safe and satisfying sex. And I think it is for women to decide. But what we did was we put it in the law. As Senator Alan also said, it was only after attending many seminars with his wife, the mayor, when he realized that in fact, many women are denied this for fear of depriving their husband.
But yes, but this is gender neutral. So this is not only an assurance for women, but an assurance for
definitely,
men.
Your Honor. It is gender neutral.
It's gender neutral.
But
yes, a man can also demand.
Oh, definitely.
And the refusal of a woman who do not want to take contraceptives may be construed as a denial of the right of a man to have access to her body because she refuses to take contraceptive. That's what I'm trying to point out. The other side of the
yes,
but anyway,
I believe, just so Her Honor knows, that was never taken up in the context of the debates.
Let's go now to another side of the coin.
Yes, Your Honor.
You said that the RH bill uphold the dignity of a woman. Now, the other side of it is that it may be degrading to a woman because the woman's body is polluted, in order that that woman, whether married or unmarried, or a minor, can be accessible to the sexual advances of a man because there is no fear of pregnancy. So just like that woman whom you said had already 8 children, then she can become a sex object to her husband because there's no fear of pregnancy.
She probably already was, Your Honor, with 8 children that she did not want. I'm sorry, Your Honor.
Do you think that is upholding the dignity of that woman simply because she can now take contraceptives and her husband can have access to her body anytime he wants?
Your Honor,
just the use of contraceptive, as mentioned by some study, would pollute her body and alter the natural course of her reproductive system.
Your Honor, I'd be happy to answer now. Can the use of the contraceptive be an excuse for anyone to demand from their partner? I don't think so, Your Honor. I think in a responsible relationship, there must be give and take, and the use of contraceptive can never be used as an excuse. Her Honor referred to the dignity of a woman. The dignity of a woman came into this picture, Your Honor, because many women have children beyond their control, despite their desire to space it or to wait a while, precisely because they do not have the tools to plan their family. That is where the dignity of the woman is affected, Your Honor. When they cannot plan and they are forced to have one child after another, of course they will love their children after the child is born, but the pain of a mother not being able to feed her child when she'd rather wait a few more years, maybe she wants to go to school, she wants to go to TESDA to get a livelihood program so that she can feed her 5 children before having her 6. That is what we are upholding. The right of these women to make choices, the right of these women to plan their family, and consistent with their obligations under the Constitution to be responsible parents. That is all we are trying to do here, Your Honor. We are not forcing anyone to do anything that they do not want. And as to Her Honor's statement on the use of contraceptive polluting a woman's body, like I said, Your Honor, medicines of all kind have some kind of side effect, and each person must decide what is right for them. If they prefer natural family planning, so be it. If they prefer to use a condom which does not have chemicals, so be it. If they want to use something else, that is what the state provides. To say that this pollutes her body, Your Honor, is a little bit an exaggeration or not accurate, because anytime you ingest something, even natural food that has been sprayed with pesticide, has some kind of toxin there. So, Your Honor, it would not be accurate to portray contraceptives in that light.
I'm sorry to disagree that the analogy is exactly correct.
Well, Your Honor, these products have passed the WHO and our FDA, and therefore, Your Honor, I have no basis, and I believe this Honorable Court has no basis either to disagree scientifically with those findings. We may disagree morally, we may disagree because we saw one study that purports to have some kind of evidence, but the conclusive evidence available, Your Honor, if these are over and above weighing the risk, the benefit and the risk, are products that are safe and effective.
Referring to the risk of
which one, Your Honor?
Contraceptive, that what I'm trying to say is that when you take a contraceptive because it is meant to cure an illness, that is different when you take a contraceptive in order that you will not become pregnant, because the risk that you are trying to avoid is having another mouth to feed, having another child to send to school. Those are the things that the use of contraceptive may bring about. It's not as imminent as when you take a medicine to cure an illness. The effect is immediate, but here when it is contraceptive in order to prevent pregnancy, the benefit is something that is long range. It's not being able to feed another child or to send another child to school and so forth. That is only my
Your
point.
Honor,
the analogy is not exactly the same in terms of risk.
Your Honor, allow me to give you another analogy. Reproductive health refers to the state of complete physical, mental, and social well-being. Not just physical, but mental and social. Your Honor, I will share with you my personal circumstance. The 4th child that I bared had a chromosomal disorder called trisomy 13. He could not see, he could not hear, he could not swallow his own food, he had an enlarged heart, and he had tumors in his kidney. He was told that he would not live. Well, thankfully, he lived for 9 months. But after that, I could not bear to see the sight of another child. My mental and my social well-being was affected. And I needed to be on contraceptives so that I could have intimate relationships with my husband. But I could not have another child. And many women are faced with similar circumstances, Your Honor. Either it affects their lives because the next child they cannot feed, or the next child they cannot take care of because they are emotionally burdened by problems that we will never experience. And that is the reason, Your Honor, that we make this available to people.
Special circumstances, but I think
But Your Honor,
the law would allow indiscriminate distribution of contraceptives.
That is where Her Honor, that is where I will beg to disagree with Her Honor. In the Senate, they use the word parang ice cream truck. Her Honor mentioned indiscriminate distribution. That is not correct, Your Honor. It will be available in public health facilities with public health professionals discussing with the women what is the best option available to them. It is incorrect to believe that we will be spreading this as if it is ice cream, as if pinaaambunan natin sila ng candy. Hindi po totoo yun, Your Honor. We take this responsibility seriously, and the Department of Health takes it seriously as well. And it would be reading malice into the law to believe otherwise.
It's not reading malice into the law. It's a question of how the law will be applied or implemented as it is written now.
As it is written now,
we're not imputing any bad motive or malice on the part of Congress.
As it is written, Your Honor, it will be available in health facilities. There is nothing else that says otherwise, Your Honor, but we know for a fact that there are groups who would like this honorable court to believe that it will be spread all over the place. First of all, we don't even have the funding to spread it all over the place. The target is the fifth lowest quintile of poor women. That is the first target because they are the ones who need it the most, because they are the ones who cannot afford.
Health facilities will precede the distribution of...
Sorry, Your Honor, what is the question?
Health facilities will precede the establishment of health facilities and the appointment of adequate medical or health care service providers will precede the distribution of contraceptives.
Actually, Your Honor, this
and
is
other reproductive health
actually,
devices.
Your Honor, this is a combined effort of the national government through the Department of Health and the LGUs. So the Department of Health will set the policies, and they will also be in charge of the funding. That is why you will find the funding in the GAA, and then they will assist LGUs in the actual dissemination of the information, but it is the LGU's health workers that will be in charge of the actual patient to health worker contact and providing the contact, the information and the services, Your Honor.
Determine what is medically safe and what is quality health care services. Who will determine
medically
this?
safe
in relation to Section 23, providing for penal sanctions?
Well, medically safe products, Your Honor, it falls within the jurisdiction of the Food and Drug Administration, the FDA.
In other words, no doctor can contradict any decision that the FDA will make with regards to what is medically safe and what is a quality health care service.
Well, like all doctors, Your Honor, I have had the opportunity, because of a child who lived his whole life in the hospital, consult with many doctors. I also took care of my father who had liver cancer. All doctors will share their opinion with you, and the law does not take it against the doctors if their opinions, if the doctor has personal opinions that state, I have a preference for this drug because it seems to be more effective. I do not like this one because it seems the side effects are quite obvious when you're of a certain age. As long as it is consistent with the literature, there is no crime being created. There is nothing punishable on the side of the healthcare provider, Your Honor.
That is not what the law says. It says the refusal to provide these medically safe products.
Is Her Honor referring to Section 23, subsection 2? Sorry?
2 and 3.
2 and 3. Well, Your Honor, Section 2 refers to medically safe reproductive health procedure. The import of that provision really is to say that health providers must provide certain acceptable procedures without need of getting consent. The issue here, Your Honor, is not the medically safe procedure, but the consent. So the medically safe procedure was simply inserted to ensure that we are not promoting a medically unsafe or illegal procedure like abortion. So the object of this is to say that health providers must perform such procedure without waiting for the consent.
But it has to be medically safe, and so there must be a prior determination what is medically safe. So who will determine this? It does not say that it is the doctor who will determine what is medically safe.
No, Your Honor, this is a general phrase that was used to ensure that we are referring to a procedure that is known to be medically and legally safe. For example, a ligation or a vasectomy. It is known to be. It was not trying to introduce some new type of procedure. That is the purpose of that phrase, legally and medically safe. In other words, hindi naman ho pinag-uusapan kung legally or medical safe. Given na po yun. The issue is, assuming that this procedure is a routine procedure, then the issue is, does he have to get the consent of either the spouse or the parent? That is the import of this provision, Your Honor.
What about healthcare services? Who determines that the healthcare services is of quality?
What provision is Her Honor reading for, so I can respond in context?
Refuse to extend quality health care services and information on account of a person's marital status, gender, age. But the thing here is personal circumstances or nature of work are included.
Yes, Your Honor.
Would this mean that a doctor should not take into account the personal circumstances, the age, and other situation of the patient?
I am happy to respond, Your Honor. What it means is that we are prohibiting a doctor from refusing to provide good care to a patient because they want to discriminate a patient because bata siya. Let's say pumunta po doon 14 years old buntis. And the doctor feels, kaya ka buntis kasi ang landi-landi mong bata ka. The doctor cannot refuse to give care to this patient because she is young, she's only a teenager, and that's why you say religious conviction or personal circumstances. A doctor cannot refuse to give health care to a prostitute because of her personal circumstances. That is what we're saying, that the doctor must continue to provide the kind of health care that he provides to anyone else, and not judge a person by these circumstances that were mentioned, Your Honor.
From what I understand from the discussions earlier, it will be the FDA who will have the final say on what is medically safe, what is correct information,
on products
what
lang.
is quality healthcare services. So the FDA is very powerful. It will set the guidelines for all doctors, and no doctor can disagree with that. And any refusal to abide by the decision of the FDA will be a punishable act under this law.
Your Honor, yes, indeed, the FDA is very powerful, but only with respect to products and devices as defined in the FDA law. I am familiar, Your Honor, because I am also the sponsor of the FDA law. So, the scope of the FDA law is medical products, devices, food, and cosmetics. It does not include the statements that Her Honor mentioned really was simply in reference to providing acceptable quality care. That has nothing to do with the FDA, Your Honor.
Thank you, Senator. You are up. It's Justice Perez.
Although the objective is the reproductive health of the woman, the same objective that was mentioned by Congressman Lagman. But in the end, it always, or the discussion eventually goes to population control and family planning. Because in the example that you gave, the daughter being the substitute wife, and you said that the purpose of this law is to have the opportunity to educate the daughter. I don't see where the condom comes in that situation. But then, as the discussion went on, it eventually reached that stage where you said that it's family planning really, which is the intention of the law, and which is acceptedly, whether it is a side effect or the main effect of the reproductive health law. What I'm saying is, and I've proposed this also for the petitioners, that we discuss the constitutionality of this law, accepting that it is really a family planning law, it is really a population control legislation. Because that is the objective that I see this law is headed for. Now, if it is an acceptable, it's constitutionally allowable to have a population control, then there is no debate about, because the objective of giving our Filipinas the best reproductive health services cannot be debated. It's not a subject of a debate. That's an ideal which everyone wants. I feel that the underlying objection against this law is that it is in effect a population control legislation. Let us attack this law with that as the reality that we all have to confront about this law. And having said that, may I make an observation, Chief, that I think that all the points that needed to be raised have all been discussed. And I suggest that we request Attorney Hilbay to just submit a memorandum on his position so that we can all be...
I would just like to respond with His Honor's permission very briefly.
Yes.
Your Honor, during the discussions in both houses, there was a lot of questions asked on whether this was a population measure, and I believe in the House there was more discussions on this because His Honor, Congressman Lagman, is actually the chair of the Committee on Population, and you were the chair at some point. But anyway, Your Honor, all references to population were removed because, at least in the Senate, I can speak for the Senate, there were those who did not want there to be any sense of this being a population measure. And then, Your Honor, I explained as chairman of the committee that sponsored the law that the intention really was to address reproductive health rights issues. Now, if in the end, the women eventually are able to on their own decide that they want to have 2 or 3 children as opposed to 5, then I answered that in the micro level, if the families get smaller, then of course, if this multiplies, there is a macro level effect. But was there an objective of government to make that happen? There is nothing written in the law because we do not even have, Your Honors will recall, at some point there was a 2-child policy bill that was there. That was not even considered. If there was really an intention, then we would have considered these type of measures to be more specific. So for now, the bill that we have may have an effect. It will have an effect if it is effective in terms of families deciding, but the law is very clear that it still remains the decision of every couple to determine the family size. Thank you, Your Honor.
Yes, Justice Peralta.
Just one question to close the session tonight, probably. Did I get you correctly that if the husband demands from the wife can refuse sex?
Well, what I mentioned, Your Honor, is that we do have a marital rape law. So if the husband, in the case His Honor mentioned, forces his wife to have sex when she does
I'm not saying that.
Did not force, just ask.
He asked
just
the wife
ask.
to have sex.
Well, of course, a man and a woman can always ask each other. I think that is the definition of a healthy relationship. You should be able to.
But the wife can refuse. And,
Yes,
she is
of course.
protected under the RH bill.
No, it is not RH law that protects her, Your Honor. I believe that the provisions in our family code and the Constitution would uphold the woman's right to have a healthy relationship with her husband and not be forced.
But he can demand safe sex. The wife can demand safe sex.
The wife, well, at any point in time, either couple should respect the will of the other. I think that is the nature of a healthy
Because
relationship.
my next question should have been, supposing it is the husband that demands sex from, or the wife demands sex from the husband, can the husband refuse? And is the husband protected by the RH law?
The RH law doesn't have anything to do with it, but I'm sure the husband can refuse. Why not? There are reasons why a husband cannot perform in the same way a woman cannot perform, so it works both ways.
Yeah.
But the
as a
RH
husband,
law would not be the basis, Your Honor.
Thank you, that's all.
Thank you, Senator, for a very enlightening presentation. We will adjourn now, and we should resume on Tuesday next week, unless the Solicitor General will agree to just submit a written memo on what State Solicitor Hilbay will be presenting next
May
week.
we respectfully request to be given the opportunity to have Senior State Solicitor Hilbay make his presentation, Your Honor.
Okay, in that case, we shall resume the oral arguments next week, Tuesday, August 20 at 2 p.m. And Senior Solicitor Hilbay will be the only one to argue on Tuesday. That will be the last oral argument. Is that okay?
Thank you, Your Honor.
Okay. This oral argument is now adjourned.
All rise. Please remain standing while the Chief Justice and Associate Justices leave the session hall.